Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Monday. It's Fun Day Monday. Today's Monday, July 13th, 2026. And there's a lot to do today. There's such a lot to do. And you know when you like have a lot to do, everything happens at the same time. Like right now, there's a guy coming to fix my tire. And of course, it's going to be exactly at the exact same time that I hit go on this live stream. So if I have to jump off for a second, it's because I have to go down and talk to the guy, tell him what to do with my tire. So there's always something. But there's always 5 things happening at exactly the same time. So here's what we're doing today. 12:45. There is the hearing in the Myles King case with Rosemary Scapicchio. This is supposed to be a scheduling hearing, and Judge Krupp is allegedly going to continue the hearing from last summer. If you don't remember, the first hearing, the evidentiary hearing in the Myles King case for the motion to dismiss, where Lally was on the stand, that was it was almost exactly 1 year ago. It has taken 1 year to even come back and talk about rescheduling this hearing. And that's wild. It was July 21st of 2025. And I've linked that stream for you below. Today's our 3-year anniversary for the channel. Thank you. I don't know if we're going to have a chance to do like a big celebration today, but maybe we'll have another day. We can do that. 3 years ago today. Where were you? Were you here? I was here. I can't even believe that hearing was almost a year ago. So we're going to find out. And remember, Michael Proctor was also supposed to testify at that evidentiary hearing and all of the reasons why he never gave Lally any of the automatic discovery and exculpatory evidence that was supposed to be turned over to Myles King. And then because of the delay and all of the shenanigans that was going on with the discovery that wasn't being turned over by the prosecution, Myles King got out on bail. He's charged with murder. He's charged with the murder of Marquise Simmons. He got out on bail because it took something like 4 years that he was in holding and nothing was happening with his case. And then while he was out on bail, he was picked up by the feds on alleged drug charges. So he's in federal holding right now in Plymouth. And it is Scapicchio Barbecue Day. They're not going to have the hearings today, but they're going to schedule a time to do the hearing. Allegedly. I don't know. And then at 2:00, I think it's in front of Judge Doolin, there's a hearing about Karen Reed's phones. Because remember, they took 2 of Karen Reed's phones all the way back in January of 2024, and they had a warrant to seize the phones, but they didn't have a warrant to search the phones. And yeah, I have the Zoom on Rosemary's, so we're going to do that. Grant Smith Ellis is also going. He's going to, as far as I know, he's going to live stream the 2 p.m. hearing for Karen Reed, but usually the mainstream media goes in there too. But lately they've just been like putting it up 5 minutes. So we have to like jump around. We have to like jump around. We're always doing things on the fly here. That's just the way it is. Apparently also this morning, there was a Sarah Grace Patrick hearing that I would like to watch with you. And then also today at 2:00 is a Lindsay Clancy hearing because her trial is supposed to start on the 20th. So it looks like we're going to be watching a lot of hearings today. So I hope you're in it for the long haul. Thanks, Michelle, for your Venmos before the stream started. And she also wants to give the mods a standing ovation. So standing O for the mods. We do have the best mods in the business right here on this channel. Yeah, Grant's going to be there. He's going to live stream it. So if we don't get mainstream for 2 p.m., we can watch Grant. Also, we're definitely going. I have the Zoom for the 12:45. And the reason that thing is scrolling along the bottom is because how many times has it happened where I would be talking to you during a Zoom and one of the Zoom participants is also listening to me and on the Zoom and doesn't know how to mute the Zoom. And then people hear my voice coming through the Zoom talking to you and they think that I'm the one who doesn't know how to mute, but it's not true because I know how to mute. I know all the things and how to do all the things. I've been doing this for 3 years now. And I think one of these days I'm going to get the hang of it. What is happening here? I don't even know. So that is where we are right now and where we will be in 10 minutes when this Zoom starts. Thank you to Unknown. Today's motivational quote of the day for July 13th, 2026. I don't know what year it is. I don't know what day it is. I can't believe July is almost half over. Where's the summer going? I don't know. It's crazy. All right. This is a quote from Unknown. Unknown said, "Don't wait for opportunity, create it." Oh, guess here's a good example of that. Me. Don't wait for opportunity, create it. Sarah Grace has started. Well, Sarah Grace has already happened as far as I know. It's done. So we're going to watch it on the replay. Watch it on the replay. All right, let's take a look at our affirmation for a badass. Thank you very much. Because everyone needs an affirmation for a badass, and you're all badasses, all of you guys. Here you go. Don't half-ass anything. If you're going to F it up, F it all the way up. Don't half-ass anything. If you're going to F up, F it all the way up. That's your badass affirmation of the day. Dun, dun, dun. Focus, focus, focus. I don't know why it's not focusing. But anyway, you know how I'm watching Outlander, right? So I'm almost done with season 1. And now I'm having nightmares about Jack Randall. Okay? If you know, you know. Like, really? I thought this was going to be a nice period piece. I thought this was going to be a nice period piece with nice Scottish and English accents and some nice costumes. And if you know, you know. That's all I could say. Yikes. I don't know anything about a hearing for Kelsey. Right, Outlander? Yeah, I'm having nightmares about that man. Like, he's coming in my nightmares now. Like, it's horrific. Thanks, Raina. Oh, yeah, it's like, I didn't realize this is going to be what it's going to be. I thought it was like a nice love story about a girl who travels back in time. And, and it's not. You're telling me it gets worse? Oh, man. Oh, man. It's so good, though. It's so good. Shady Norfolk County DA's office is here and says, I live by that quote. I don't do anything halfway, even screw up. It's all or nothing. All or nothing. A lot of new members today. Jenna is not soup. Hospice nurse. You know the hospice nurses are the angels. All nurses are the angels. Are you guys back to work at Brigham? At the Brigham? I hope so. Mish Props, thank you. And Ann Bozzarelli's been here for 33 months. She's an OG. She says, happy anniversary. Happy anniversary to us, Ann. Thank you, Mrs. Bouquet, for your super sticker. I straightened you out. I don't know what happened. YouTube's been blocking people. So if you do get blocked for whatever reason, a lot of times it's inadvertent and or YouTube is, I don't know, wonky. You have to send me an email, but you have to send me the link to your channel. Sending me an email and not even telling me your name or your username or anything is not helpful. And I can't go back and forth with you 14 times. Please send me the link to your channel. So, Mrs. Bouquet, thanks for your super sticker. Hi to Harrison if he's watching today. Soap. API says one of my kitties on my YouTube, one of my kittens, YouTube picture. I don't know, that looks like a dog to me. Chaos Monkey appeared, yelled, then jumped into bed and curled up in my arms as soon as she heard your intro song. Oh, I love that. 2:30 a.m. in Australia, and we're watching Melanie together. Oh, I love that. Sorry it's so late for you. Gigi is here. She's engraving all the silver clinks, and she says, happy anniversary to us and your incredible show. Thanks for being here for 13 months. Julie Jensen says, busy day in Massachusetts. Thanks for covering all of it. Also I had on my calendar today, remember that woman, Jeanette McCausland, who was in, I think, Wellesley, and she took the lives of her two children and fled to Vermont. I had it in my calendar that there was supposed to be some sort of hearing today, a probable cause hearing, but I couldn't find it anywhere. So I'm not sure where it is. If it's anywhere, I don't know. Thank you for thanking me, Jules. Shady, Norfolk DA's office says I love all your coverage and all this mess. Thanks for being here for 17 months. You're amazing. All right, I'm going to jump into the Zoom, but I'm going to tell you right now, once this Zoom starts, I am going to zip it, which makes some people happy because they don't like when I talk so much. But that's the other downside of the Zoom is that we recap it after. We don't recap in real time. Oh, thank you, Joanne, for your Cash App. It says thanks for your work and for keeping us informed. You are very, very, very welcome. Remember Brandon ruined it for everybody when he didn't know how to mute on the Zoom that we saw. I forget what hearing that was. One of the Karen Reed ones, maybe. Oh no, maybe it was one of these. All right, Zoom is up. Not a Bear is Ardsmuir Prison, season 1. I think it was called something else, like Wentworth Prison or something. That was the one, the one that I'm talking about. Yeah, you know what I'm talking about. Yeah. Hazmat Addict Gaming says, thanks to you, I got 5-Finger Death Punch concert tickets. Love you. Oh my God, that's awesome. 5-Finger Death Punch. Fantastic. Buy the tickets, do the things, because you never know. You never know when you're not going to be able to. I hope you have the greatest time. Let's go, Brandon. I can't wait to see what Judge Krupp does with this, because remember, he did such an about face when that hearing happened the first time. All of a sudden, it wasn't happening. He was like, go make me some charts. And it's been a year. Thoughts, questions, comments, concerns. Thank you, Kyle. We'll look at that later. I don't have to kill some time right now because right now, we're just waiting for this to start. I just said that. I just said we're going to look at the Sarah Grace Patrick hearing when we're done here or done after the 2 p.m. And
Counsel, I just called the case for the record. I don't see Mr. King on the Zoom yet. They did confirm 12:45. Counsel, while we're waiting, if you could identify yourselves for the court and the record.
Good morning. Good afternoon, Your Honor. Jennifer Hickman on behalf of the Commonwealth.
Good afternoon.
Thank you.
Your Honor. Michael McGee for the Commonwealth. Good afternoon, Your Honor. William O'Driscoll on behalf of the Commonwealth.
Good afternoon, Your Honor. Rosemary Speech on behalf of Mr. King.
Good afternoon, Your Honor. Nicole Scapici on behalf of Mr. King.
All right. Do we have, Mr. King is at what facility? Is he at Plymouth?
Plymouth County House of Correction, Your Honor.
Okay.
12:44. We are a minute early. I don't know.
Your Honor, I can tell the court that he is expecting to be able to be zoomed in. I did speak to him about this hearing.
All right. Let's give it a minute or two.
Here we go, Plymouth is in now. I'm submitting them.
Great.
Thank you.
Mr. King, are you there from Plymouth?
Yeah, I'll get them right now for you.
Okay, thank you very much.
All right, Mr. King's right here for you.
Okay, Mr. King, you able to hear us okay?
Yeah, I can hear you. Good afternoon.
Okay, all right, good afternoon. Before you got on, we called the case and the lawyers identified themselves for the record, but we haven't gotten started yet. We were waiting for you to join. Let me ask counsel where things are. Let's start with Ms. Hickman.
Your Honor, as the court is aware, the Commonwealth's filing date for its opposition will be on August 12th. We were here today. You indicated on our last date, Your Honor, that you wanted to do a scheduling as to when to start an evidentiary hearing. I believe Your Honor had indicated at a minimum you wanted to hear complete ADA Lally's testimony. I believe we're here today to figure out or determine what witnesses would be necessary with the continuance of this hearing, Your Honor.
All right. Do you have a view about that? Other witnesses?
I would defer to ADA McGee on that issue, Your Honor.
On the
Okay, Mr.
discovery,
McGee?
thank you, Judge. On the discovery piece that we paused last July 21st of last year, the Commonwealth would suggest that continuation of ADA Lally would suffice from the Commonwealth side.
Okay. Attorney Skip. Oh, I'm sorry, Ms. Hickman, go ahead.
Your Honor, and the other issue where, since we're discussing witnesses, I'm not sure, obviously the court does not have the Commonwealth's filing relative to the second supplemental motion to dismiss. If the court does believe that testimony is necessary, there are two additional witnesses that the Commonwealth would raise relative to the second supplemental motion to dismiss.
I'm sorry, the Commonwealth would be asking for two other witnesses?
Correct, Your Honor. As ADA McGee just stated that relative to the discovery, the Commonwealth believes that ADA Lally would be sufficient for the issues being raised by the defendant in his motion. If the court determines that witnesses are necessary to the defendant's second supplemental motion to dismiss, which is relative to Michael Proctor's personal phone and the bias, this evidence, the Commonwealth would propose two witnesses as to that issue, Your Honor.
And they are?
That would be Detective Louis Ballard of the Milton Police Department and Officer Henry Colligan, also of the Milton Police Department, Your Honor. So the Commonwealth in this opposition does not believe that that testimony is necessary relative to race because it's not an issue of selective enforcement.
All right, Attorney Scapiccio.
Thank you, Your Honor. I am suggesting that we call, we finished with Lally, that Proctor is on my witness list, Tully's on my witness list, Lieutenant Collins, Patrolman Binda, Officer Cargan, which they just said they were going to call, and Detective Mark Similito. Those would be the witnesses that I would intend on calling for the issues of discovery and or the issues regarding Proctor. I haven't had the opportunity to read the Commonwealth's response. I may end up adding somebody as a result of what they're saying in their response, but I haven't seen it yet, Judge. I just want to leave that possibility open.
Okay. I think what makes sense is for me to get a copy of the Commonwealth's response in mid-August when it's due. Take a read through that and then have counsel submit a list of the witnesses that they think need to be called and why, what they would offer. Doesn't have to be in huge detail, but it has to give me some sort of a proffer as to why their testimony would be useful or necessary. I'm getting a reverb on this. Let's see. I wonder if everybody who is not speaking can mute themselves. Well, let's try that again. All right, that's better. I think Ms. Capiccio is going to need until after August 12 to be able to give me her list of witnesses and an explanation as to why they would be necessary. So I'm going to suggest that we pick a date to complete Mr. Lally's testimony. And we'll take up at that time whether there are other witnesses that we need to hear from.
Judge, can I ask what date would you want me to file that witness list with you? If we get the Commonwealth filing on August 12th.
I was thinking that you might file by the 21st of August.
Sure, Your Honor.
And that could be a concurrent filing date, so I'll get a list of witnesses that the Commonwealth thinks that we may need or not on the 21st as well. So August 21 will be a list of witnesses.
Is that an
And an
in-court filing,
explanation.
Judge? I'm sorry, I didn't mean to interrupt.
I didn't hear what you said.
Is that an in-court filing, Judge?
No.
Thank you.
And I would like to schedule a hearing to at least complete Mr. Lally's testimony. If people are available the last week of August, we could do that. What's the practical reality of getting Mr. King into Dedham?
I don't know the answer to that, Judge. That has to be requested by the, my understanding is it has to be requested by the Assistant District Attorney to the U.S. Marshals, and they'll give us availability and send it to the clerk's office, I believe. But
Can I ask anybody, hold on a sec, can I ask anybody who's not speaking to mute themselves? Okay, now, Attorney Capiccio, your understanding is the same as mine, which is that the DA's office needs to request through the U.S. Marshal's office or the AUSA to the U.S. Marshal's office some sort of a HABE or some sort of a accommodation to allow Mr. King to be transported to the Superior Court. And so if we pick a date at the end of August, that'll give us enough time for the DA's office to make that request to the Marshals. Do we have, so if you can check our list, do you have a date that we might put aside? Maybe the 24th?
Your Honor, ADA Lally's not available on the 24th.
Okay, is he out all that week?
He is not. We do have on the team a child care situation, so we could do one day that week, Your Honor.
Okay, what day?
Any day.
Any day, Your Honor, either 25, 26, 27th, or 28th.
25 and 26 work best for me, Judge, if that's available.
I missed what you said, Attorney Capiccio.
I'm sorry, Judge. 25 and 26 work best for me if that's available.
Okay. How does the 25th look on our calendar?
We're scheduled to panel of wait cases for not no further continuances.
All right.
Morning,
All right.
the afternoon.
2 o'clock hearing?
I'm not sure we're going to finish Mr. Lally in 2 hours, but we can make it at 2 p.m., Your Honor. I don't know what Attorney Scapiccio understands where we are with this questioning.
All right, so let's see if we can find a full day.
26th, Judge, for that work?
26th does not work. How about the 28th?
28th doesn't work. How about the 27th?
Probably, given what these are probably move those if need be. We could do that, and we can definitely do it.
Oh, we may be on trial with that with you in the morning.
But if we had declared it, maybe
Yeah, which case is that on the one?
Myles.
Oh, yeah, I know that case. So, we tried to see what was going on that. Let's do, Did you say that you could make the 27th work?
I could, Judge. I have to move something, but I could make it work.
All right, how about 9 a.m. on the 27th?
Sounds great, Judge. Thank you.
It works, that should work for the Commonwealth, Your Honor, based on what ADA Lally gave us as his availability.
You said that does work for you?
Yes, that was one of the available dates provided by ADA Lally.
Okay, great. So just to recap, I will get a opposition from the Commonwealth August 12th. We'll get a list of witnesses that the parties would like to call and an explanation of why by August 21st. And August 27 at 9, we'll continue the hearing with Mr. Lally. If I take a look at the witness list and it's clear to me that one or more of the witnesses should be called, I'll give you the heads up in case we can fit a second witness in on that day, the 27th, and that person happens to be available, but we're not going to have a big window of time to arrange it. So it's much more likely that we're going to need another day. Okay.
Thank you.
So we'll hold the 27th. All right. Anything else, counsel?
No, Your Honor. Thank you.
Very good. Thank you.
Excuse me, Your Honor.
August 27th at 9 a.m., transportation Habe's issue.
Excuse me, Madam Clerk.
Yes.
Can you just make sure that the Habe gets sent to Plymouth County and then we'll send it to the U.S. Marshals for approval? They don't want the court sending it directly to them. It has to come from the holding facility.
Oh, that's interesting. Okay, no problem.
That's
All right, thank you.
a new, sir, that's a new development as I understand it. In previous instances, we've always had to arrange transportation to the marshals through the U.S. Attorney's Office.
No, I've been in this booking department for 15 years, and that's the way we've always done it. Because we're the one that's we're holding the individual in our facility. So we do the transport, so it has to go through us to the U.S. Marshals, and then they'll send us a response if it's approved or denied.
I have no problem doing a belt and suspenders, but it would make me a lot more comfortable to also get a federal court order that he be transported. So we will send a Habe to Plymouth, but we'll also make sure that the DA's office goes through the U.S. Attorney's Office to get appropriate sign off from a federal judge.
Okay.
Okay, very good. Thanks for the heads up.
Thank you. Have a good day.
Okay,
Thanks, everyone. Thank you, Your Honor. Thank you, Madam Clerk.
okay.
Thank you. Thank you.
Okay, so that's it. But we knew that was going to be it because we knew that today was the day to schedule the day to come back. But the good part about it is that they have set aside a full day to get Lally back on the barbecue. Put it in your calendar, folks. That's going to be August 27th at 9 a.m. Lally's coming back to Rosemary Scapiccio's barbecue, and he's not going to get away so easy this time. In fact, even the ADA, Jennifer Hickman, said, yeah, Your Honor, I don't think 2 p.m. is good because I think we're going to need more time with Lally. Remember, Lally's the reason that Myles King was let out on bail after 4 years because Lally and Proctor, maybe together, were just deciding not to turn over evidence because, you know, who cares? Lally on the stand had absolutely zero F's to give. He couldn't have cared less. It was so obvious. Zero intellectual curiosity, zero follow-up, zero tickler system, all the things. And Proctor was supposed to come in, but he didn't show up for his subpoenaed date the first time because he just went on vacation because, you know, that's what he does. And so they're thinking they may need to call him back this time. But of course, I don't know. I feel like everyone's protecting Proctor. And remember, in the second amended motion, in the second motion to dismiss is when Rosemary Scapicchio dropped all of the extra bombs, all of the extra text messages that she had of Michael Proctor, indicating his virulent racism, bigotry, everything he ever said about Black people, Asian people, all the things. Oh yeah, there's the number 27 again. Thank you, Dobie Mama. So the Commonwealth apparently hasn't even responded to the second motion to dismiss yet. Their opposition will be due on the 12th of August. And then at that point, the ADAs said the only other people they would even think of calling would be 2 detectives from Milton Police Department. And then Rosemary said, oh, no. I want Proctor. I want Tully. I want Collins, whoever that is, and 2 other guys from Milton PD. The judge then said, why doesn't everybody give me your list of witnesses by August 21st? And I'll decide. Because Proctor's, oh, I thought you said why Proctor. And then they have set aside August 27th at 9 a.m. for a full day of testimony from just Lally. And then we'll see how much Proctor is protected, or whether he's going to have to come in and testify about all the horrific things that he said about people like Myles King. His jokes about planting evidence. Rosemary, I remember, made some arguments about how he believed the white witnesses at the scene and not the Black witnesses who actually were first on scene and rendering aid to Marquise Simmons. There's something about a dying declaration where Proctor put in his report that Marquise Simmons, as he was dying, said, Mizzy Cash is the one who did it. That's Myles King. And the other people didn't hear it. So there's a lot of questions there about Proctor's bias, inherent bias. And I think he needs to take the stand, but we will see what Judge Krupp decides. And then that argument at the end about getting Myles King to court, the reason that there's an issue with that, or it's just a different procedure, is because now Myles King, as I told you, is in federal holding because he couldn't keep himself out of jail after he got let out on bail. And we looked at those charges too a while ago. I can't remember exactly what they are, but it's alleged drug charges. So the feds are holding him. That's why apparently the procedure is a little bit different. The court officer or the guard or the corrections officer who was with Myles King in the room got his FaceTime on the Zoom to tell the court that, no, this is the way you need to do it now. You got to send your Habe petition to the federal lockup to us, and then we send it to the marshals. And it looks like they're going to dot all their I's and cross all their T's so that Myles King can be at the next in-person hearing, which is going to be August 27th, because of course it should be over a year since the first hearing started, because of course, right? Hospice nurse Autumn, thank you so much for your very generous 50. She says, nurses love you too, Melanie. Stick with Outlander. Thanks. I will. Sandra M, thank you for your Canadian super sticker. And then you said, I forgot to type my message. I would love Rosemary to be Karen's lawyer. She takes no crap from anyone and is not afraid of judges. Karen's got a whole team already. I think it's too late for her to change attorneys at this point. Thank you, Link 2019, for your 10 on top. Thanks for your super sticker. South Boston Kev said, Brandon, please mute your mic. People don't forget, bro. I know, it's ridiculous. Thanks for tuning in from across the pond. And Karen, thank you for gifting 5 memberships. And to those who were so randomly gifted by YouTube, we're going to hang out together until 2 p.m. for the next hearing, the Karen Reed hearing about getting her phones back. Do you think she should get her phones back? Somebody ordered that she should get her phones back, but then they said, but you know what? We're going to hang on to them in case the Commonwealth wants to appeal. Did Cosgrove appeal? I don't know. Will Cosgrove appeal? He only had 30 days from the date of that order. And we don't know if he did, because here's the thing. We can't find that case in the docket. It's filed under a search warrant number. It's not searchable. It's not on the public calendar. And It's very secret. It's very secret. Do you think Karen should get her phones back? Michelle, thanks for being here for 24 months. She says, best channel and mods on the tubes. I love you with all of my heart. Right back. And Victor Man's been here for 2 years. Thank you for your loyalty and support. And Kansas Granny, been here for 8 months. We have a very loyal following who actually stay on the tubes of you with me for hours at a time. And I think it's so funny when people come into the comments to complain about how long my videos are. I'm like, well, we have a community here. We engage with each other. We talk to each other. That's what we do. It's engagement. I can't record videos and edit them. I just can't. It would take me too long. There are people who do that and they do it very well. And I suggest if you like something shorter, then absolutely 100% go watch them because they do great work. Let's see. April, thank you very much for your Venmo. She says happy anniversary and thanks for all you do. You're the reason we all stay sane in these crazy times. You're a sweetheart. Thank you. Susanna says you brighten every day. Blessings. Thank you, Susanna. Lisa said you're awesome. Thank you. Thank you, Lisa, for your Venmo. And Michelle, I thanked you already. Here's what I think we can do. Let's talk. Well, let's wrap this a little bit. I can't wait for Lally to come in and testify on August 27th. I can't wait. Somebody said he's fired. I didn't hear anything about Lally getting fired. I know nothing about that. So I deleted it because I can't confirm it. And so I don't even know. I have no idea. She did get the Lexus back because they auctioned it off. So she got the Lexus back. That was auctioned off, but it wound up selling privately. I think whoever was auctioning it off took a better offer privately, and so the auction actually didn't happen. Lally did not get fired, so please don't spread misinformation. I have not heard anything about that at all. That's why misinformation gets deleted. Don't know anything about it. People are writing it. Okay, so what I think we should do is watch the Sarah Grace Patrick hearing because that happened a little bit earlier. And that's a case that we need to catch up on. Her trial is supposed to start in August. And in the meantime, we can find out if there's going to be a mainstream camera aside from Grant in the 2 p.m. hearing for Karen Reed. So let's do that. Let's kill all the birds. No, I mean, that's not kind of like not a really great analogy, but let's go to Georgia and see what's happening with Sarah Grace Patrick. If you don't mind. Lindsay Clancy has a hearing, but it's going to conflict with the 2 p.m. on Karen Reed. So we're going to do Lindsay Clancy on replay. But my understanding is she does have her final pretrial conference at 2 p.m. Yeah, they did refer to Lally as ADA. Yeah, they're still referring to him as ADA. So he's still working. I don't know why people start rumors, but then people run with it. We're covering Karen Reed at 2, and we're going to cover Lindsay Clancy after that. Okay? Because I'm assuming there will be a camera in there. Thanks for distracting me, says Free Edric Fost. Friend, oh, I'm so sorry. I'm so sorry. My heart breaks for you. That's terrible that you lost your friend. I'm really sorry. Tina, our best thoughts, gifted 5 memberships because she's amazing. Thank you. Let me see. For those of you who are not familiar with Sarah Grace Patrick, I have a whole playlist on her. Karen's in Norfolk Superior Court, but it's not on the public calendar. It's not even on the docket at all. Not one bit, because it's under some weird search warrant number. It doesn't have its own case number. And so it's very strange. Hang on for a second. Well, please. Sarah Grace Patrick was 16 years old. I think she was 15 at the time of the shooting. She was 15 years old on February 20th of 2025 when she is now accused of and being held in custody in Carrollton, Georgia, which is Carroll County, Georgia, shooting and killing her mother and stepfather in their bed on February 20th of 2025. She is charged with 2 counts of murder. Her 5-year-old half-sister found their bodies and she was surrendered by her biological dad. And we have I have several videos on this. I'll link the playlist below because I didn't know we were going to jump into this right now. The prosecution says that they have mountains of evidence. However, nobody's ever seen any of this mountains of evidence. And it turns out that on February 14th, which was Valentine's Day, there's a witness who saw her parents held at gunpoint during a drug deal gone bad inside their house. And there's a lot of other shenanigans going on here. And this girl has been held since her arrest in something like the summer of 2025 because she made TikTok videos looking for an influencer to cover the case to help her find out who killed her parents. And so everyone thinks that she's guilty simply because she asked some people on TikTok to help. All right. So let's take a look. This hearing is only maybe 45 minutes long, and that will bring us right up to 2 o'clock for the Karen Reed hearing. So let's take a look. Remember, Dusty Hightower is the judge, and he looks like Jake from 16 Candles, right? And this is the hearing from earlier this morning. He's been in solitary for over a year. Thanks, you guys, for filling me in on some of the details because it's been a long time since we covered this. And I believe that her original attorney is no longer a public defender. I think she's got a new lawyer now. And this is a case we've been covering very closely. Remember when Jennifer Coffindoffer said she was going to get fat in prison because there's all the carbs, like she was body shaming her? There she is. Isn't his name Dusty Hightower? Is that this judge, or am I making it up?
If we could.
My mic is muffled. Who's saying my mic is muffled? I'm playing the court feed for you now.
If we make an announcement outside, I did tell people that they can come back in. If they're here in support of this case or interested in this case, tell them they can't come back in the courtroom before we get started. I just asked everyone that was not offended to step out so we can get through some announcements. But I did let everyone know that would be allowed to come back. All right, we're going to go ahead and get started. This is the state of Georgia versus Sarah Grace Patrick. This is our calendar call for the trial week of 8/3. It's my understanding that the defense has a short motion that they'd like to be heard. And then the state, I believe, is also has a response. So defense, whenever you're ready. Thank you, Your Honor.
And as the court said, we filed a motion, so I will be brief on, I won't go into the case law as much because I know the court's not seen it. So, and again, for the record, I am. There you go. And for the record, my name is Sean Hoover. I have recently joined, or I am the attorney for Ms. Patrick moving forward. Latoya Williams was the attorney. She no longer works with the Public Defender's Office, so I will be moving forward Your Honor.
Now, I know that you paused, you said recently, you overtook this case in February.
February, that's correct. For me, it's recent. I apologize. There's been a number of trials since. So I've been on the case since February, Your Honor, and we're asking for a continuance today regarding Ms. Patrick's case. I know the court has already read the case law involved. Just to put a couple of highlights on the record. For starters, Your Honor, once I took over the case, I put an entirely new team on Ms. Patrick's case. With that said, I got the case, there was a lot of discovery involved, started to go through the discovery while I was trying other cases. Once I realized there were certain issues that hadn't been addressed when Ms. Williams took represented Ms. Patrick, I started to create a team or bring a team in that could address those particular issues. At the beginning, I thought it was just a chain of custody issue, and it turned into a lot more than that. To give you an idea or a little more of an understanding, I brought in Mary Dayton, who is an attorney with the Public Defender Office. I worked with her when I was with the Capitol Office. She does a lot, has done a lot with juvenile clients, especially juvenile clients dealing with capital cases and dealing with forensics. What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the Sheriff's Office, Police Department, and just evidence in general. With that said, we brought in also a mitigation investigator, Olivia, who's at the table with us as well, who also deals with capital cases, also deals with juvenile cases, but also deals with the mitigation aspect of it. Once Ms. Dayton and Olivia came in, we found out that based off of current case law, not only with the United States, but also in Georgia, certain issues weren't addressed when Ms. Williams had the case and Ms. Williams announced record. Mainly because of the age of Ms. Patrick when the shootings actually occurred. Because Ms. Patrick was a juvenile at the time, case law is a little different when it comes to, for one example, sentencing in regards to how and when a juvenile can be sentenced to life without possibility of parole, death penalty, or life with possibility of parole. Because of those issues, I believe it was about 2 weeks ago, I believe Olivia just said that we got the defects information around June 30th, which literally wasn't that long ago. Yes, Ms. Williams had an expert that, to be nice, did some work on the case, but the expert didn't have Ms. Patrick's, and the expert I'm talking about, Dr. Schaefer, didn't have Ms. Patrick's defects records when he did his evaluation, when he spoke to Ms. Patrick and family members, when he came to his ultimate conclusion. Now that we have the defects records, that has opened up, lack of a better term, a whole other can of worms in regards to not only sentencing because of Ms. Patrick's age, but also our theory moving forward, especially crossing certain officers and certain witnesses based off of the evidence that we did receive from the state.
He's really throwing her initial public defender, LaToya Williams, under the bus. I really liked LaToya Williams a lot. I mean, she took a job in private practice because she couldn't afford to be a public defender anymore, and she got a good job offer, and so she left, and she was devastated. She fully believes in Sarah Grace Patrick's innocence. Her entire team did. They actually offered to help, but this guy, he seems on top of it. His name is Sean Hoover. He's the new attorney. And for those of you who are new to this case, I'm going to read you, and I'm going to put the show notes below the video as well. Everything that we're doing is scrolling along the bottom. So if you ever come in and you're late, all you need to do is look at the scroll at the bottom to see what we're covering. Sarah Grace Patrick has been held without bond since her arrest. But let me just give you the show notes that I'm going to put underneath this video for those of you who are just tuning in. Sarah Grace Patrick, who is now 17 years old, stands charged with the murders of her mother, Kristen Brock, age 41, and her stepfather, James Brock, 45, on February 20th, 2025, in their Carrollton, Georgia home by multiple gunshots. Sarah was not arrested until July of 2025, and the evidence against her has not been revealed. It is alleged that Sarah reached out to TikTok content creators to help find the real perpetrator and to help the story gain traction. The state seems to believe that shows consciousness of guilt. Sarah's motion for bond was denied after a hearing, and she remains held without bail in solitary confinement pending her trial, which had originally been scheduled to start on June 5th of 2026. And this again is Judge Dusty Hightower. I was right about that, in Carrollton County, or this is Carroll County, Georgia. She was originally represented by public defender LaToya Williams, who I thought was a queen. And, the question is there really a mountain of evidence here? Because that is what the prosecution told everybody. We watched old press conferences. We watched an interview with her father, who stands by her. Her grandparents also stand by her. And the sheriff's director of communications did that crazy press conference, remember, that there's mountains of evidence against her. And it was interesting. I'll link the playlist below. No other suspects were even investigated, even though I think it was her stepbrother who saw them held at gunpoint something like a week prior to their murders. And there was a back door that goes right into the small home, into the parents' bedroom. They also questioned why she didn't hear gunshots. And there's a lot more to this story. There was a motion. There's a motion to, I think, reduce her bond or let her out, and that was denied. And so here she sits still since July of 2025. So she's been in solitary confinement for now what has been a year. And so this is the hearing. He's talking about chain of custody issues, and he's talking about the expert that LaToya Williams hired not being good enough. Let's listen to the rest of his argument.
So with that said, we're asking for a continuance for multiple reasons. The first one will be because now that we actually have a team in place that can actually address the issues facing Ms. Patrick because of her age at the time of the shooting and because of all of the background history that Ms. Williams, she just didn't know about because she didn't have it. Literally, we sent you the order and you got the information to as quickly as possible. But we're talking about over 10 years worth of information that now we have to go through, not only for sentencing, but to combat certain things that I believe witnesses and especially officers are going to say on the stand in regards to their investigation. So we're asking for a continuance for that reason, because we just need more time to go through all of that. Again, the case law, like I know the court's aware of the case law. The case law, not specifically, the case law points towards it's a sentencing issue, which it is, and we need more time for that. However, without going into more detail, there were certain statements made and certain reports that were written from the lead investigator and other officers, which tells me now that those defects records, the mitigation aspect of this case that we thought was something that we had, that wasn't as important during the trial. Well, now it is, because based off of what we've read and based off of what we received, it will be an issue in this case, especially with the lead investigator. So the first point we're asking for a continuance is because we now have the team put in place to address the issues specifically based on the mitigation aspect of this case, which was not addressed before. Dr. Schaefer had an evaluation that the state has and the court has, that he did not have the information that we have. And based off of that information, more needs to be done so that I can adequately protect Ms. Patrick's interests moving forward. Furthermore, we're asking for a continuance, Your Honor, based off of evidence that we believe is still outstanding. And when I say that, again, when Ms. Williams had the case, the state of Ms. Williams announced ready for trial. And I understand based off of the information that the parties had at that time, they believed they were ready. However, once I took over the case again, I thought this was just a chain of custody issue, and it turned into something a lot bigger. And to give the court an idea without going into too much detail about our theory, since I've taken over the case, I've actually been able to delve or dive deep into it. There are issues with what officers did in this case. There are issues with the Georgia Bureau of Investigations in this case, and we have started to get more information, more evidence from the Georgia Bureau of Investigations and from law enforcement.
What does that mean to you? Problems with the Georgia Bureau of Investigation. Remember who it was that was heavily involved in the Edric Foss trial? The Georgia Bureau of Investigations, but specifically their cold case unit. What do you think he means by that? He thought it was just chain of custody issues, but it seems to be, he says, real issues with what happened with law enforcement. Tell us more. His name is Sean Hoover.
That said, the state and I met on Friday in person to go over the physical evidence in the case, and we talked about that as well. And the state is helping us get more information. And to be clear, this is not an issue that like the DA was hiding information. This is more of, I saw an issue that I believe Ms. Williams just didn't see. And it snowballed into something a lot bigger than just a chain of custody issue. So,
I mean, as far as we know, there's never been a weapon found. There's never been, as far as we know, like they're just not releasing any information. They were talking about some communications that she might have had. You know, there were some boyfriends she might have had. One of them, I think, was picked up on perhaps a gun charge. She had no access. She didn't have a driver's license. She had no access to a car. The whole thing is very sus. So I don't know what physical evidence they have because they haven't told us anything. But apparently, according to Sean Hoover, it's snowballed into a lot more than just a chain of custody issue. So it's getting interesting. I don't know how much of an adjournment he's going to need, but this girl's been sitting in solitary for a year now. Maybe we could, I don't know. He's got a whole team. I'm glad. I don't think he's a private attorney, though. I think he's a public defender. I don't think she even had access to a weapon. Ugh. We were planning on this for beginning of August. How much of an adjournment do you need? Will Dusty Hightower give it to him?
now we're still trying to get information from Georgia Bureau of Investigations to fully understand the forensics in this case, to fully understand the chain of custody issue in this case, to fully understand the procedures in this case. And we are literally still requesting information from GBI that's still coming in. And now we've actually asked the DA to help us out on that because this is information they need as well. So this isn't something that's like, well, we knew about this earlier. This is literally, again, started out as a chain of custody issue, and it has snowballed into something bigger to where we're going, and this deals with possible 702 dowry issues moving forward. We're literally dealing with forensic evidence. We're literally dealing with chain of custody issues, proper procedure issues, not only through local law enforcement, but through the Georgia Bureau of Investigation. So we're asking for a continuance on that as well, because there's still information coming in. And finally, Your Honor, and again, this is not me saying the state withheld anything, because I honestly believe the state did know about this as well. But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports. This officer is on the witness list. But from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the report. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong. My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person.
Last week, this officer went to the DA and said, I have a feeling that the gun was pawned. They don't have a weapon. At the time of this shooting, she was 15. I'm really sorry to report to you that her parents, there's evidence that they were dealing drugs and that they had gotten involved with maybe some bad people and that they maybe screwed some people over in a drug deal because Sarah Grace Patrick's stepbrother saw them held at gunpoint in their own kitchen a week before their murders. They decided to arrest and charge Sarah Grace because she was the only one there and she didn't hear the gunshots. And now there's a law enforcement officer who just went to the DA a week ago and said, I had a hunch that the gun was pawned. Is this another case of pinning it on the girl? And DB says that Sean Hoover has a ton of defense experience for gang shooting cases, by the way. Well, that's good, right? That's good. He had a hunch. Oh, we're back in Georgia, and wow. All right, here. He's going to say, correct me if I'm wrong. My understanding is this officer had a hunch about the pointing of the gun. Let's listen.
My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch turned into, it went to another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea these two people existed. We had no idea.
Well, that's just a little bit of a chain of custody issue, isn't it? If he went there a year later, well, a year and a half, because the shooting was in February 2025, and all of a sudden he goes there and he shoots the gun to try and test it and then gives the gun back to the guy. And where's the gun been in a year and a half? What? This poor girl. I'm going to rewind it just a scooch. What is this, Michigas? Is Mama MSN? It is a Michigas. Sarah Grace Patrick, state of Georgia versus Sarah Grace Patrick.
Another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion. And again, Ms. Williams of the state announced ready for trial for January. The state didn't know about this. We are now in a position to where I honestly don't know, was this one rogue officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to know.
What do you think? Is it just one rogue officer or were there more involved in this? Welcome to Georgia. Welcome to the GBI. Could have been an informant. No pawn shop would take a gun from a minor, but I don't think that they're talking about her selling it to a pawn shop. Maybe it was one of her boyfriends because she had like 2 boyfriends who might have owned guns and they were like maybe older. They don't think she pawned it.
Now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the 2 people, well, it is more than 2 people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information that we have uncovered since I've taken over the case and I brought my team on that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this is not the DA's office that held any of this information. This was now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem. And as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law.
They never investigated any other suspects. Now he's talking about other suspects.
Court's already the case law, so I'm not going to delve into that. But we are in the position now that I understand this trial was set, or this case was set to go to trial. I understand that this Patrick has been in jail this entire time. She and I have had this difficult conversation, but I am in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we are asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the lead investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief. But now we know GBI evidence, that there's still more coming in, still more information coming in. Forensic evidence, there's still more coming in. We will be having 72-hour hearings. We have to on specific information. What will be admitted, what won't be admitted, who will be an expert. There's a chain of custody issue. And again, now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about. There's new, again, forensic evidence we need to talk about. There's new
Did he backdate the report like Tully did and Brian Walsh? I think it was Tully. It was one of them. Backdated a report, and it was just normal. It was just normal to backdate reports. It's what they do. This guy, a year and a half later, is all of a sudden writing a report because I think they know they have nothing. There is no mountain of evidence, but they're going to have a whole lot of egg on their face if they don't convict the girl.
Contact information we need to talk about, and this is not from the state. This is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With all of that said, Your Honor, due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole, as a defense attorney, I need more time to uncover or to just delve deeper into all of this new information we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this because another officer popped up with new information we didn't know about before. Like, this is not I'm grasping at straws. There's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
Thank you. State, do you have a response?
I do, Judge.
State, you'll approach and give your response.
Thank you. I do want to touch on a couple of things. First, in basically the order that defense counsel went through them. He said that there is a new team that they put together specifically for the mitigation or issue, specifically regarding the defects documentation. I'm going to break that down a little bit. First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're now asking to change their expert.
Is DFACS the Department of Children, like the Department of Families and Children's Services? If anybody knows for sure, I think that's what they're talking about when they talk about DFACS, I think.
If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case, and they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that, it was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the DFACS records that we brought up, we got those DFACS records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
So the state's position is that the vast majority of the DFACS records that were turned over, say, about 3 weeks ago, are duplicates that have already been available to everyone.
Yes, either the documents themselves or the information contained therein. They are information that was out there long in advance, things going back to the history of the defendant in relation to her interactions with DFACS.
Thank you.
And to kind of cover this mitigation issue, judges, opposing counsel pointed out, the case law on this largely focuses on a sentencing issue. There is no requirement that the court has to allow additional time or heightened requirements for the defense. Second, if that is genuinely an issue for sentencing, a verdict favorable to the state being reached, potentially sometime in August or September or later, should it be required. The court can always set aside sentencing farther down the line so that the defense would be able to investigate these sentencing issues. There are other alternatives other than pausing the trial. Second, as far as the outstanding evidence from the GBI, that was basically a request for, I'm going to use a term of art here, benchmarks, testing procedures, documentation that the testers make during their process. The defense did not ask for that in February.
Uh-oh. What happened? No, that was their screen that went black.
The hyperbole of defense counsel, but we do not have a rogue officer running wild. We had an officer who tested a firearm in relation to this case, or any case, to be honest. It was not the firearm used in this case. They tested it, they ran it through NIBIN, they did all of the proper tests.
I'm sorry. It wasn't the firearm in this case. So it's not important that you should turn it over to the defense. So you don't, what you're telling us is that you don't have a murder weapon. And a year and a half later, you're still looking for a murder weapon because a guy had a hunch, but you don't think you should have to turn it over because it wasn't the murder weapon? Is that what this guy just said?
Procedures for that firearm to an officer of defense counsel. But we do not, I do appreciate the hyperbole of defense counsel, but we do not have a rogue officer running wild. We had an officer who tested a firearm in relation to this case, or any case, to be honest. It was not the firearm used in this case. They tested it, they ran it through NIBIN, they did all of the proper testing procedures for that firearm. It's not related to this case. Multiple firearms were tested in relation to this case. None of them are the firearm in question. This is just one of those that the defense was not aware of prior to Friday. It's the exact same thing as all the other firearms we have. There's going to be potentially 2 new leads to chase down, but those things are law enforcement officers. They're going to be here. They may be brought up by the state for cross-examination. If not, the defense can put them up under their own subpoena power in their case in chief. There's nothing to that would require any additional time. Again, the rule here is the 10-day requirement. We are 21 days out as of right now when I stand here in front of the court. We think that there is no necessary foundation legally for the state to continue this case. We think factually there is no requirement that the court continue this case. We think that overall the needs of justice do not demand a continuance in this case. Instead, they demand that this case be reached for trial on August 3rd as that.
Just out of abundance of caution, while I know the rule, some may not. You mentioned 10 days.
Sure.
And that we're 21 days out. I know what that means.
Yep.
Can you explain?
Again, so the rules for discovery in Georgia require that all of the information from the state be turned over to defense counsel 10 days prior to trial. For us, we are 21 days out as of today. That counts business days and weekends. So we do have a significant amount of time to give things to them. There may be more things coming, and I can illustrate this with something that was mentioned up in.
Dude, you're 21 days away from trial, and you may have some more things coming. You didn't think you might want to have your case all tied up in a bow before now? Okay, tell us more. Tell us the more things that are coming aside from the gun that was tested that wasn't used in this case. So the guy, the rogue, didn't think he had to tie it into this case. Sounds to me a lot like the Russ trial, but let's keep going. Tell us more.
Opposing counsel's brief. They were just in receipt of the defendant's calls while she has been in custody. I'm going to turn those over at 10-day. Again, anything from July 1st through whatever that 10-day is. But I cannot turn over things until I have them. So they're not going to get those until 10 days. As much as I would like to give them the calls that she is making next week, I can't turn over documentation that we don't have. The rule allows us to present evidence as late as 10 days before trial. or more specifically, to make our files available to the defense 10 days before trial. Here we are 21 days out.
I believe you're making reference, Mr. Hoover, you didn't really address this during your presentation, but in the motion that the defense presented, there was a reference to a large amount of evidence that was submitted. There was a certain terabyte amount, I believe, that was addressed in that particular motion. My understanding is that y'all kind of resolved that, and the bulk of that were these calls that you were just turning over. Is that correct?
That's right, Judge. So to kind of unpack that completely, the 2.5 terabytes of information that defense counsel mentions in their brief, that's the entirety of the case. That is all of the jail calls, all of the phone dumps, everything. 33 gigabytes was turned over a couple of weeks ago to the defense. I had spoken to Mr. Hoover prior to let him know these are the things that are coming. They were not surprised by any of those documents. So everything has been turned over. I think it was just a communication error between opposing counsel and their investigator in regards to what was actually turned over. There was only 33 gigabytes turned over. Again, most of that was jail calls with the defendant, and those can't be turned over until they're actually made. So the totality of what we have was turned over, not even to counsel now, but to prior counsel significantly before trial. The overwhelming majority of that 2.5 terabytes was turned over to Ms. Williams well before the trial that we were going to have in January.
Yeah, except he's a new attorney, and 2.5 terabytes is a lot. If anybody's boots on the ground in Norfolk Superior right now, tell me if Karen Reed's hearing is going on in the same courtroom 25 that the Myles King hearing was just in. Please.
Which would have allowed Ms. Williams to make her announcement ready, which she made in January. Is that correct?
Absolutely. Absolutely.
Thank you. Anything else to say?
Nothing else. Thank you.
Brief.
Yeah, I will be brief. So, Your Honor, I do want to start with the back and forth that you and the state had with the 10 days prior to trial.
And again, that really was just to solidify. We have a lot of people in the courtroom. Yes, people hear things. I know their family, people that are interested in this case on both sides. And I really was just trying to get the legal requirement out there so they could understand what you meant by that. Because that, as lawyers and my position as a judge, we're used to these dates and these time frames. But a lot of people in the audience, they don't know what that means. I just want a little clarification there.
Yes, and to give just a little more clarification, Your Honor, the state is correct that in the state of Georgia, they have 10 days to turn over discovery to the defense. 100% correct. The point that the state kind of glossed over that they didn't mention that I have to mention is that the state and Ms. Williams announced ready for trial, and this trial is supposed to go in January. New evidence literally came to existence Friday, yet like literally 3 days ago. The state can't say, well, we have 10 days to turn everything over and everything been turned over when they can't themselves say that they have all the evidence. That's the problem. We are literally getting evidence now that we did not have before. Now, what the state said was, well, this is a gun. It went through the same test that all the other guns did. It wasn't one of them. I don't know that because the officer that didn't write a report for like the last 3 years is now saying that I'm supposed to just take the state's word for it. As a defense attorney, I have to investigate this. At the point where the state makes this bold assertion that, well, this is a gun that we tested like all the other guns, and it doesn't exist, we gave it back. I have to do more. I have to see those tests. I have to first, before the test, I have to figure out how he came up with this quote unquote hunch. I mean, we're in a murder trial, a double homicide, and now rogue officers are bringing in evidence that no one knew before and saying, well, I got it off of a hunch. The state didn't bring that up. The state would say that this is just another gun that didn't test as the fire weapon, or the actual weapon is arrest. I can't go with that. The court can't go with that, and a jury can't go with that. As a defense attorney, I have to first start with, what were you doing to where you didn't write the report at the beginning? Who was your commanding officer? Did you follow procedure? The state will say, well, we have 10 days to do all. Well, we don't, Your Honor, because now that's a whole new part of my investigation that I have to do once I get those reports. We still don't even have everything from this officer. And again, it's not the DA's office, but we don't have enough from this officer. So when the state says, well, we're still within, 10 days of trial, the state can't stand up here right now and tell you that they know they have all the evidence because it's not possible at this point. They announced ready for trial in January, and we're literally getting new evidence right now. When it comes to GBI and the bench notes, the state wants to say, well, it's just bench notes. It's more than that. Law enforcement did something. They turned over evidence to GBI. I knew there was something wrong with what law enforcement did because I thought it was a chain of custody issue. Come to find out, GBI literally had to restructure everything and go back to law enforcement. So we're not asking for just bench notes. We're asking for what happened at the beginning, what went to GBI, what GBI had to relay back to law enforcement, and what GBI officially did afterwards. So the state's trying to minimize what information that we're still looking for, and that's not the case. We're not talking about, I understand, an interview. We're talking about more than that. In regards to the defects.
Karen's case starts at 2. So where are you seeing that? Invisible woman. Karen's case is supposed to start at 2. It's 1:50 right now.
Your Honor, we asked for Ms. Patrick's entire defects file. The state wants to say, well, they had some of the information, turned it over to Ms. Williams, and Ms. Williams' expert talked about it. Agreed, they had some of it. We're talking about, Ms. Patrick was a juvenile at the time, but we're talking about over a decade's worth of defects records that not only the state didn't have, Ms. Williams didn't have, and their expert didn't have. So the state's trying to cherry pick, well, this is just this little bit and this little bit, so it's not that important. Well, it is, because yes, there's a rule for 10 days. And just to back up a little bit, the state said that I've been in this case since February, and I just started asking for June. 100% correct. I've literally been in trials around the state when I was told that I'm taking over this case. I couldn't take the case in February, a double homicide, and be prepared to argue motions to say this is what I need at the end of February. The court knows, as an attorney, previous attorney, that's not how murders work. That's not how cases work. I picked up the case in February. I didn't get a new team or new experts to figure out new information. I put my team together once I was told Ms. Patrick's original team was gone, and now this is my case. I have to put a team together. The state will say, well, now I'm asking for new experts, and it's June. That's not how this works. This snowballed into new evidence has been uncovered. More information has told me there's more evidence getting outside of free. To wrap everything up, Your Honor, there has not been enough time now that there's so much more information. And at the point where the state can't stand up here in front of you and say, Your Honor, we have more than 10 days left. That's the rule. And we can guarantee that all the evidence is turned over. They can't say that because they don't know that for a fact. At this point, we have to have the contingency. The state literally asked or announced ready, not knowing all the evidence in the case. As Ms. Patrick's attorney, I cannot do that. I will not do that. I will be ineffective. And we're asking for more time because there's more evidence out there that we do not have.
Thank you. I do want to make one slight correction. I believe in January, the state actually announced not, it was Ms. Williams' defense counsel that announced ready, and I believe the state that announced not ready. They both had announced ready in January. I will try the case in January. I believe the state had announced they were not ready, and I believe the sole issue, the only issue that was left in January was a report from the doctor. There was a preliminary report that was provided to defense counsel, which defense counsel then provided to the state. Defense said that they were ready and able to proceed with trial despite not having full reports. That they thought they were sufficient, adequate, and prepared to do a full, proper defense of Ms. Patrick.
DB put the spoiler in here. Is he giving them an adjournment? Because everyone's squawking that the other hearing is starting, but it's not. It's not going to start until 2.
The state announced that the judge, we see some issues in the preliminary report, and we believe that we cannot be prepared without the full report, and we need to be offered the proper opportunity to have our own expert review the full report. That, as the state, we're entitled to that privilege. It was at that point that I decided to continue the case and even acknowledge that I believe Ms. Williams she even needed the full report. And I believe I had placed that on the record at that time, even though she was willing to go forward with the preliminary report. I believe that she did need that full report to do that job. And I believe that was the only reason for the continuance in January. I'm listening to both sides. I should have a ruling in. I need to have a ruling out of the way very quickly so that everyone knows what to anticipate. I do have court.
Dina, is it the same courtroom? Is it courtroom 25? I'm going to jump on the Zoom for there because it may have better audio.
The rest of the day, I have court tomorrow in separate county. My intention is to have it in order to y'all. I'm going to say that later midday Wednesday, but I really want that to have that order out by tomorrow. So give me till midday Wednesday just in case something happens. But I'm really shooting forward tomorrow's meeting to have that order prepared. As I indicated to y'all when y'all came up to these conference, the only thing that can delay that, however I rule, I really do want to make sure that I have the procedural history correct. I've already asked my court reporter to pull the transcript from January, so I'll make sure that I get that language correct. If needed, I need to use that in my word. So that's the only thing that may take me a little bit more time. It's just making sure I have that procedural history accurate to support whichever ruling. I appreciate both of y'all being here today. Appreciate the arguments that have been made. I'll have the order today Wednesday, if not by tomorrow.
I apologize. I wasn't here in January, so I didn't know. Okay. I need to say the state asked for a continuance, was granted a continuance in January because there was one sole issue, like the court said, that they need to be prepared for. I'm now saying there's not one sole issue that I need to prepare for. There are multiple issues that I need to prepare for, and we're asking for the continuance for that reason. And furthermore, it's still information the state doesn't have. So the fact that they're still trying to break the trial, but they don't have the information that I'm literally saying we still need, says a lot. So the state asked for a continuance for one sole issue, it was granted. The defense is asking for a continuance for multiple issues, and it's not something small, it's something major. The state still doesn't have that information. We're asking for it.
You've already made your point. And I do want both sides to be aware. I'm giving you a little leeway today. They're just random arguments that are made after I've given you time to make your arguments. We'll follow slightly different. Yes, sir. This is not a time for arguing back and forth in a debate type fashion. It's an order. Right? We take a specific order. You presented, state presented, I get an opportunity to make a vote. And then I've announced when the ruling you make. I think that should suffice. I appreciate your zealous argument. I will not let this case get out of hand. I just want to set the tone early.
Okay, that is Judge Dusty Hightower. He's going to reserve his ruling. And we are now going to go back to Norfolk Superior. And once this Zoom starts, I will be muting because this is why we can't have nice things. Because people don't know how to mute. And if I can find a better feed, we will take it. Sometimes the Zoom is very helpful. We are now going to pivot to the Karen Reed hearing on phones. All right. I know it's a lot. We're getting a lot done today. And just got to change this banner. Give me a second while I type it up. There we go. I thought Grant Smith Ellis was also going to be live streaming, but I don't see his up yet. And the Zoom may be the way to go on this for today. Remember, they've had Karen Reed's phone since January of 2024 when they were trying to indict Karen and Aiden Carney for conspiracy to commit witness intimidation. That grand jury did not indict. No true bill was returned on that. And they still have her phones. And the phones were ordered to be returned, except the judge said, oh, well, they can hang on to them. All right, we're also going to get a Lindsay Clancy feed, which we're going to jump to after Karen Reed. So it's a full-on day. It's a full-on day. We went from Norfolk County to Georgia to Norfolk County. Then we're going to go to Plymouth County for Lindsay Clancy after that. So buckle your seatbelts because, it's going to be a bumpy day with everything on the calendar. I know that Grant is there, but he doesn't have a live stream up. So how about I'm going to do it my way. I'm going to leave the Zoom on unless they don't turn the Zoom on, and then we're going to go somewhere else. Okay? All right. Usually CBS Boston is in there with a camera, but Dina, if you're in there, is there a mainstream camera in there? CBS Boston is in Plymouth right now for Lindsay Clancy, so let me know. Sometimes I like the Zoom better. If you would prefer to go watch it on a different channel, you are free to do that. Please do. I won't get hurt. I won't be upset. Yes, I see that other people have streams up. I don't know what the quality is going to be like. Again, if you would like to go there and watch it, just go there and watch it. It's not cool to redirect people other places when they're right here. Okay? Okay, it's just, I don't know. Common courtesy, common YouTube courtesy is all. That's all. I wish it was Sunday is your fun day, Dave Matthews' neighbor. Thank you, Susan, for gifting 5 memberships. You're amazing. Betterow is right. Hi, Melanie. I missed you. Oh, where you been? I missed you too. Susan, thanks for being here for 12 months. Amory says, long streams with Melanie make my day at the office so much better and go by so much faster. Thank you. Does anybody think Karen Reed should get her phones back? I do. Gigi. Thanks, Gigi says, sounds like that mountain is a molehill in Sarah Grace Patrick. Sounds like there's some shenanigans going on there. And that trial just got a whole lot more interesting. Abby became a member. Welcome. I think in the interest of justice, and especially because of her age, they're going to have to give her new attorney a continuance of at least, I don't know how long he asked for, but in the interest of justice. And the reason they were talking about sentencing is because she was 15 when these murders happened. And it doesn't sound to me like they have a whole lot of evidence against her, even though the sheriff's mouthpiece said at her presser that they had mountains of evidence. I think it's Judge Doolin today, Vicky. I think it's Judge Doolin. Thank you, Vicky Andrews, for your 10. I think it's Judge Doolin. Yeah, Judge Canoni said to give him to her, Flower Child, and I think somebody else did too. I remember if it was Krupp or Doolin, but he said they could hold on to it in case, in the event of an appeal. And the thing is, you have 30 days to file a notice of appeal. So did Cosgrove ever do it? I don't think so. Oh, thank you. True TLC gets it. Imagine having a YouTube show that you created, developed, and made successful, and then having randos in the comment section telling you when to speak, where to go, what to do. Wild, I know. It's crazy. It's crazy. I hate that she's in jail too. And they did make two different motions, right? To try and get her out on bond. Yep. She was denied bond twice due to flight risk and safety concerns. The judge found her dangerousness. They thought she was a danger to the community. She doesn't even have a driver's license. And her father, and because, there was like, didn't her grandparents offer to keep her there? But like, I think wherever she wanted to go was out of state, just like right over the Georgia border. As I recall, it was a long time ago. It was the last time that we covered Sarah Grace Patrick. I want to say it was in the beginning of the year. Cosgrove never meets a deadline. No, he never meets a deadline, and he never has any ramifications for his behavior. He's like a child. It's like he gets all the time in the world. Triple dip Cosgrove. We do love Judge Doolin, though, don't we? I know I do. The crazy thing, oh, sorry for the misophonia, folks. I forgot to mute my mic while I took a sip. I thought I did. The crazy thing about this phone hearing on Karen Reed is that you can't find it in the court docket. It is filed under some random search warrant number. It's not under a regular case number. So it is unavailable to the public. It doesn't even show up on the public docket, which they publish every single day in Massachusetts. Here we go.
Ema.
All right, ladies and gentlemen, guys, everyone can come in, turn yourself in, please be quiet, thank you.
Number 7, Your Honor, is Commonwealth versus Kenneth Dexter. This is 26 CR 26.
Mr. Atwood, how are you? It's the afternoon. Good to see you. How you doing?
Back practicing.
We got Keith McCrae, I think, for the other side.
I haven't seen him. I've seen my client. He was out.
Well, that's good. That always helps. Look at all your stuff. That was voluminous.
You know, it's, yeah, I want to make sure you have everything.
Hey, Joe. Oh, here he is. There's Keith McCrae. Mr. Atwood's case.
We are on the record at number 7, Commonwealth versus Kenneth Dexter, docket 26 CR 26. Beginning with the ADA, can attorneys state their appearances, please?
Good afternoon, Your Honor. Keith McCrae for the Commonwealth. Hi, Mr. McCrae.
Jack Atwood for the defendant, Your Honor.
Hi, Mr. Atwood. So it's on for compliance. Mr. McCrae, have you turned everything over to Mr. Atwood?
I believe everything has been turned over. There is, I'm still waiting for the, drug lab file. But I have everything, everything else. I have the body worn camera. There were, multiple search warrants, although they don't pertain to this particular defendant. And I believe everything else is.
Okay, why don't you come up and talk to me? Come on over. We'll put this over for a motion filing date. Mr. Atwood, give us a date that works for you.
How far out is the court thinking?
Give us something in late August, early September.
Early September would be good for me.
Fine, just give us a date that works and we'll accommodate it.
How about the 10th of September?
That's a fabulous date.
That work for the ADA?
It does.
September
Yeah,
10th.
September 10th for filing motions.
The Dexter return to court, September 10th. There'll be 2 p.m. hearing in this courtroom. That'll be for in-court motion, filing a motion. Thank you.
Thank you.
Very much.
Thank you.
Thank you, Mr. Clerk. Very welcome. Number one is Commonwealth versus Todd Conley, 23 probation transfer 9-3. Can the probation officer identify himself, please?
Yes, Bill Canfield, Norfolk Probation.
Hi. Let me take a look at what you got. Good afternoon, Mr. Conley.
Good afternoon, Your Honor. I have a few.
Hold on for a second.
Sorry.
Oh, you got a lawyer?
No.
All right, then hold on. Let me just read it.
What that is,
Yeah.
oh, Mr. Conley filed a motion for early termination. There is one issue. I have not been able to contact the victims of the case. That is the first issue. Second issue, I really don't have any, an objection, but I just wanted you to know Mr. Conley did have some issues with some positive tests.
Yeah.
And that is what I've handed up to you.
When is probation over? When did he get put on probation? When is it over?
Sorry. Mr. Conley, he was put on looks like 11/2/23, and there's a 5-year sentence, or probation rather. So
yeah.
Looks like 11/2/28.
Okay, you got to notify the victims.
Yes.
All right, this is what I'll do. I'm in this courtroom until the end of September. I'll put it on one of the days that I'm here, and he has to notify the victims. What you're asking for is something extraordinary. It may be warranted. I don't know. I got to take a look, okay? But I'll give you a date in September to come back and do that.
Say anything or no?
What's that?
Can I say anything or no?
Yeah, go ahead.
I mean, the only reason I'm asking you on is I've been on almost 3 years. I work as a recovery coach in the court system.
Good for you.
And I just bought a home. I've had a baby. I've done a lot of good things in the last several years.
Yeah.
My question is, it's hindering me through employment. The last 2 jobs I went on, they gave me the job.
Yeah.
I ran my record, and it's coming back as open, and they wouldn't give me the job. So I can't further my employment. And this is one of the reasons that I've asked for this. I've done everything the court has asked me to do.
No, it sounds like you've done a good job.
It had a.
Listen, I'll give you a date in about a month. Sounds like you got some good arguments, and you're presenting yourself pretty well, okay?
Thank you, Your Honor.
All right. Give me a date so that you can notify the victims of this.
I'm just asking for maybe we're in July now, like mid-August, a Monday.
Mid-August.
Monday or Thursday?
Monday or Thursday in mid-August.
August
13th?
No, 17th.
Does that work for you?
The 17th, a Monday?
Yeah.
Sure.
That works for me.
Fine with me.
Return to court August 17th. I'll be hearing in this courtroom, 2 p.m.
Thank you.
Okay, have a nice
I
day.
appreciate it.
Bye.
Theo Pamphil has number 2, Commonwealth vs. John Fannin, 24 PT 211.
Is there a motion? Let me take a look at it. How is he done?
Mr. Fannin has done well, Your Honor. I do have similar issues with the summoning the victims. I've been working with the Victim Services Department, and they are attempting to contact the victims of the case, number one. Number two, this case came from Suffolk Superior. So I think Mr. Fannin, he sent notice to Norfolk.
And then we got Mr. Fannin. Come on up.
Okay.
Why don't you come up? Come on up.
August 17th as well. That'll be a 2 p.m. hearing. Motion to modify conditions. Number 3, John Rayshot, 25 CL 148. We have attorney Frank Middleton, attorney Tim Pellerin.
Good afternoon, Your Honor.
Good afternoon.
Attorney Pellerin on behalf of the Commonwealth Special ADA.
Hi. You got some discovery motions that were filed?
I do, Your Honor. I also have a notice of discovery that I'm filing with the court today,
Excellent.
if I may. Thank you.
Thank you. Okay. Let me see. What were the motions that were filed?
So, Your Honor, at the arraignment date, I filed approximately 6 Rule 17 motions. I did go ahead and provide the Dwyer notices ahead of time. I understand our hearing that was previously scheduled for the end of June was continued until today. So the notices had the old date. However, I have not received any sort of notification or otherwise that there are any parties objecting. I can tell you the surviving victim is present today. I understand he's the representative of the decedent's estate. He has no objection to these records being obtained, so I would just ask the court allow them as to stages 1 and 2 at this point.
Any objection? Yeah, that's fine. So your motions are allowed. You have so many that it will take me a bit to endorse them. So
Yes,
why don't we have, Ryan can send you notice tomorrow.
Absolutely,
okay?
Your Honor. Thank you.
I'll hold on to it. Why don't you come over and talk to me?
Yes, Judge.
That is continued to August 26th. That'll be a 2 p.m. hearing in this courtroom. That's by agreement.
Thank you, Your Honor. Thank you, Mr. Clerk.
Oh, yeah. He's not here, is he? No, Sam. Krusky Jr.'s here. Why don't we call it and see where everybody is?
Your Honor, we have 3 co-defendant matters, numbers 4 through 6. Dominic Manigo, John Montalvo, third co-defendant Arsenio Andrade.
Hang it out.
Beginning with the ADA, can the attorneys state their appearances, please?
Good afternoon, Your Honor. Jennifer Hickman, the Commonwealth.
Hi.
Board Secretary, I have defended this is Dominic Manigo, and I believe Joe Krowski is second behind me, and here is co-defendant for Mr. Juan Montalvo.
Okay. Hi, Mr. Majacomo. How you doing? Where's Mr. Krowski?
Bring it up the rear. There's a motion.
Yeah, I read it.
Oh, so I'm asking, well, that's the report, but it appears that with Judge Krupp.
Yeah, I think you gotta go in front of Judge Krupp on that, but I read it. I thought you'd be more impressed.
You thought who would be more impressed?
You, I read it.
Oh, okay. No, you read my stuff.
Yeah, there you go. All right.
This isn't the first time.
Yeah. Mr. Krowski.
Good afternoon.
The beard is gone, kinda. How you doing?
I'm doing well. How are you?
Good. So we'll talk about this part first, and then we'll talk about Mr. Spencer's individual issue. So it's on for pretrial hearing. Does everybody have all the discovery?
So I can speak. So there's 12 notices of discovery. Took the liberty last night to go through them all, and it's coming in piecemeal. I'm not blaming the Commonwealth. That's more my problem. And I offered to provide a terabyte flash drive today, but then my sister, I think, resent all the links today. So I might just see one more status date just to make sure I have everything.
Yeah, that's fine.
If I can just clarify the record.
Go ahead. Of course you can.
Thank you very much. So there are 12 notices of discovery. The discovery has been provided as discovery comes into the Commonwealth, and the last notice of discovery was provided on June 11th. So last night I got an email that I saw this morning, obviously, from counsel stating that notice of discovery 1, 4, 6, 7, 8, 9, 10, 11, he was unable to open, probably because the expiration, the window on share file had expired. Many of these notices of discovery provided via email, and the largest one was a phone dump that was provided in hand to counsel, all three counsels on April 14th. So I do have that to provide in hand. It's much too large to file for counsel, but I sent all of the discovery yet again, and I also recorded the dates via email to counsel where they've been sent before. So I have provided over and over, Your Honor. I just don't want the record to be unclear that the Commonwealth has provided all the discovery since January as it came into the Commonwealth. And I am going to hand the phone dumps again to counsel.
Judge, just on behalf of Mr. Andre, I don't think anyone's suggesting that the government's not turned over the Rule 14 discovery. I will say it's a discovery that's being measured in terabytes, so it's voluminous. I think we would all benefit by another date just to make sure that we have everything that we're entitled to.
That's fine.
And then we can file motions accordingly. On behalf of Mr. Andre, you set his conditions of release. I just emailed a motion to the clerk and to the prosecutor looking for a very slight modification from 5 p.m. to 8 p.m. And it's accompanied by a letter from his employer. If we could put that on for a brief call, if we could just address it at sidebar briefly.
I remember this. I think the first time I was rather dubious, but I will say he hasn't had any problems.
No. He's actually had to leave work early or not go to some of his jobs.
Where's he working?
He works for a landscaping company. It can be verified by probation. He's not had even the slightest of hiccups as it relates to reporting home on time and otherwise complying with everything that's been said.
They let him out from home confinement to work, like, what was it, 8 to 5 or something?
8 to 5, we're looking till 8 p.m. to allow him to work till approximately 7 and get home by 8 o'clock.
Well, it's been 3 months and there haven't been any trouble, so I would allow that if I have a motion to that effect.
You do? Well, your clerk.
I kind of do. All right. I'll actually write it on this.
Okay.
So it's allowed Monday through Friday, 8 a.m. until 8 p.m. For work purposes only.
Yes. Maybe in the future we can revisit that.
I don't think so, Mr. Krowski, but I've always given you a lot of You know, you're trying really hard for your client, and I respect that. But I think this is about as far as I'm gonna go.
Message received.
Yeah. All right, so the new schedule is, he's in the house 8 p.m. to 8 a.m. Well, he's out of the house, I should say, 8 a.m. to 8 p.m., Monday through Friday, for work purposes. Now,
It'll be noted on the docket.
Attorney Curley, Mr. Spencer has filed a motion for his client.
Correct.
It was Judge Krupp who heard it initially, so it would be my intention to send just Mr. Spencer's client over to Judge Krupp.
I understood. I just don't know that that's necessary. So Judge Krupp heard the initial 58A hearing and set the initial bail and the conditions of release. Then it was in front of Judge Boudreau, who then allowed the defendant 2 months ago to go to church with 48 hours permission to probation. And then just a couple weeks ago, Judge Boudreau allowed the defendant to take his daughter to leave the house for 3 hours between 9 a.m. and 12 p.m. to take his daughter to the park or to do shopping for the daughter Monday, Wednesday, Friday, 9 a.m. to 12 p.m. So my understanding is that counsel is now asking that the defendant's GPS be removed and he allowed not that the GPS be removed, that he just be allowed.
Vacate home confinement, which was initially imposed by Judge Krupp. So that's an ask. And I think where we have the person.
Bill can talk to the two of you. You guys can come up too if you want. Portion of it over to Judge Krupp on Dominic Menigo. Give me a date that works for everybody.
So your case can cancel it. You can pick whatever. We can pick whatever date. We're in August, Judge. Before August 14th, I can pretty much, with the exception of August 4th. I can do that. Well, I can't. I'm up to August 14th. So any day before August 14th. No, you're like, you ordered me. I can do further status. It's so much status. Yeah, the trial conference. You need to. I can do the 10th. You can do the 10th? 10th and 11th I can't do. 12? 12. Can you do 12?
Actually, I can't do it.
Can or you can't? I can't. You can do the 12th? I think the 12th.
I can do the 10th.
What date?
August 12th.
August 12th, fabulous. That work for you, Mr. Magiacomo?
On board, Judge. Thank you.
And what type of hearing will that August 12th be? Type of hearing?
Trial hearing.
Further pretrial hearing, August the 12th, all three defendants. That'll be a 2 p.m. call in this courtroom.
Thank you.
Thank you.
Thank you.
Okay. Remember that Menigo case, which is Mr. Spencer and Attorney Curley will go over to Judge Krupp for his consideration.
Do you mind taking notes? Sure.
Yeah, I allowed it on the papers that I gave to Brian.
Absolutely.
Thank you. All right, what else we got?
Number 8, Your Honor, pretrial conference, Commonwealth for Steve Williams, 26 CR 35.
Hi, Mr. Crenna. How you doing?
Williams here.
Good afternoon, Your Honor. Debbie Clerk, Commonwealth.
Hi. So where are we with this, Attorney Curley?
I had just discussed a motion filing date based on the 4 corners of the search warrant And I believe we selected September 25th.
Please. I have a lot of things due the beginning of September, and then I have to do a memorandum with this one. That's why I'm asking.
Okay, yeah, that's fine.
And then there's going to be Four Corners. I think we have all the discovery. The only other issue, Your Honor, Williams was out in the district court on $10,000 with some conditions. When the indictment came back, the trafficking amount was a little bit lower, so there was, by agreement, the bail went from $10,000 to $7,500. Conditions still stayed. There was he had no curfew on the weekends because he had work, but he had stay at home on the weekends. He is asking, given the fact that it's been over 7 months, no problems, is that if the weekend stay at home could be lifted.
That's denied.
Thank you.
Can we have that date again by agreement?
September 25th, please. Motion filing.
Mr. Williams, return to court September 25. That'll be a 2 p.m. hearing in this courtroom. That'll be for filing of motion.
Great. Thank
Thank
you.
you.
John, thank you.
Take care.
Thank you.
All right, I'm taking this.
Yeah, all right, let's do it. Okay, we'll do it.
Next matter does not have a docket number. It's the matter regarding search warrant in the case of Commonwealth of Karen Reed.
Good morning, Your Honor. Excuse me. Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth. Good morning.
You got a phone, you got to take it outside the courtroom, please. Hi, Mr. Cosgrove. Hi, Mr. Herbalis. How are you?
Good afternoon, Your Honor. Attorney Ben Herbalis for Ms. Reed.
Okay.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed's interests.
Good afternoon.
Nice to see you.
Good afternoon, Your Honor. Evan Wolk on behalf of Ms. Reed.
Okay. Good afternoon. Let me just talk you up and sidebar just for a second. Mr. Jackson, the floor is yours. Go right ahead.
Thank you, Your Honor. I appreciate the time and the court accommodating us this morning for the, or this afternoon, I should say, for the purpose of talking about what we filed. I'm going to try not to be repetitive, but I do want to address in no small part, the opposition that the Commonwealth has filed. And really, our motion comes down to a single promise and a single breach of that promise. The promise was independence. That's how we got here. Mr. Cosgrove was appointed on the promise of complete independence from the Norfolk County District Attorney's Office. And on February 19th in this courtroom, the special prosecutor, I think, slipped and admitted in his own words that the promise had been broken. Everything else in the Commonwealth's opposition, as I read it, is an effort to sort of talk past that fact. And I want to address that in no small part in some order. And I want to start with the standing issue. That's where the Commonwealth leads in their opposition, and I want to lead in my response to that opposition. The Commonwealth's lead argument is basically the conflict, in as much as it might exist, it belongs to Aidan Kearney, not to Karen Reed. It's a clever argument. I can hand it to Mr. Cosgrove for leading with that because it is clever, but it's also wrong. The warrant doesn't exist in the abstract. It exists because the Commonwealth has advanced a theory, a stated theory on the record, that basically Karen Reed potentially engaged in some sort of witness intimidation. That's the foundation for what the Commonwealth has suggested precipitated the warrant in the first place. And it's on the strength of that, what we believe is a very flawed and a false theory. They went to a judge of the court and they said, we need a warrant naming her, Karen Reed, and they seized her phones. And today, in this moment, the special prosecutor is actively litigating to keep her phone away from her, out of her possession. So in terms of standing, when the Commonwealth stands up and says Karen Reed is basically a stranger to this conflict, she has no standing, this is Aidan Kearney's conflict, that's simply not true. I'd ask the court to inquire a few questions of Mr. Cosgrove. Whose phone is it that's at issue? Whose name is on the warrant? Whose privacy is on that device? That's not Karen Reed borrowing Mr. Kearney's grievance. That's Karen Reed asserting, in the most direct way that she possibly can, her own interests that the law recognizes. The interest in her property, which the government seized and is improperly holding. The legal standards and why we're here. Let's be clear about what the governing law is at the outset, because the entire Commonwealth's opposition depends on the court and in hopes of the court applying the wrong legal standard, which I'm sure it is not want to do. The right one is in place. When the right one is in place, the entire argument by the Commonwealth falters. The rule for prosecutorial disqualification, and I say that with an emphasis on the word prosecutorial because I'm going to get to a point that Mr. Cosgrove cites in his moving papers that is incorrect citation and incorrect application of the law. The rule for prosecutorial disqualification in this Commonwealth is told to us by a couple of cases that we cited in our moving papers and the court has in front of it, PISA and Ellis. And it's not ambiguous in the least. PISA versus PISA versus Commonwealth deals with prosecutorial conflicts of interest that are treated with absolute strictness. And the words matter. No showing of prejudice is necessary by Ms. Reed at all. The court does not weigh whether actual harm resulted. It does not weigh whether actual prejudice exists. We don't have to show any of that. The law does not ask whether the conflicted party, in fact, changed any outcome. We don't have to show that. And Ellis completes that rule by saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interest in fact or, and this is the big whopper, in appearance. It's those two words that I want to focus on for a quick second. In appearance. That phrase is the whole case. The law does not ask whether the special prosecutor, whether Mr. Cosgrove was actually influenced by Mr. Morrissey or anybody else in the Norfolk County District Attorney's Office. It asks very simply whether the public looking at this arrangement can have utter confidence that he was not in any way influenced by the DA's office. In other words, the law asks a very, very clean question, Judge Doolin, and the answer is very clearly as clean. It is no. The public cannot have that confidence. And I ask the court to just hold that law in the back of its mind for a second as I talk about the next point of the argument, which is the actual indication, the evidence of the breach of that promise. And this is because of the facts of the case. There is a breach because of the facts, and the facts are not very friendly to Mr. Cosgrove's position. And they're also not in dispute because they came right out of the special prosecutor's mouth. On February 19th, from the podium, Attorney Cosgrove told the court that he would basically sit down with the district attorney's office. He was going to go through all of their options. They would weigh the pros and cons of all their options and discuss those pros and cons, and then get back to the court in due course. His actual language is this, and I'll quote him. Quote, I'd like to take some time to look at Judge Krupp's decision and to meet with the district attorney's office, the Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss with them our various options. And we are going to give, are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done that, I'll get back to you as soon as possible, end quote. Those personal pronouns and the possessive pronouns used in that phraseology, in that paragraph, are not of insignificance. Who is the we? Who is our options? Who's the our in those sentences? Obviously, it's in perfect context. It's Mr. Cosgrove, and it's the Norfolk District Attorney's Office. In an unscripted and what I would consider to be a pretty unguarded moment, Mr. Cosgrove betrayed exactly what's going on here and who's really prosecuting this case. And I put prosecuting in quotation marks, but who's advancing or forwarding this case against in terms of the search warrant against Ms. Reed. He isn't investigating Ms. Reed. They are investigating Ms. Reed. He isn't holding her phone. They are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words. According to Mr. Cosgrove, he could not and was unwilling to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Ms. Reed's phone unless and until he met with the district attorney's office. He explained on the record what needed to happen before he could make that decision. And I'll just repeat it very quickly. Are we going to give Ms. Reed's cell phone back? Well, the unanswered part of that question is, I can't make that decision, Judge, without speaking to the DA's office to find out what they want to do. Number two, are we going to move for reconsideration? Who's we? Him and then the district attorney's office. That's who he was referring to. The unspoken answer to that question is, I don't know. I got to check with the DA. The third question he posed, are we going to file a notice of appeal? Again, the unspoken answer was, I can't decide that, Judge, not today, because I need to first sit down with the DA's office and figure out what our various options are. It couldn't be any clearer. This is with the completely walled off Norfolk District Attorney's Office, the conflicted office, the office headed by an alleged, a self-described victim of Ms. Reed, Mr. Michael Morrissey. He was the authority Mr. Cosgrove admitted he needed to go to before he could make any other decisions. And there's no other way to read his words. The fact is, he was not authorized, obviously not authorized to make any strategic decision about Ms. Reed and her phones until he got prior approval from the very office that was the subject of the conflict. And that's the problem. It's not a good look for the DA's office. It's not a good look for the Commonwealth. It's not a good look for Mr. Cosgrove. And appearance, when I use those words guardedly, it's not a good look because appearance means everything in this case, as we'll see. So Mr. Cosgrove, in his moving papers, he sees the problem, obviously. He's a very intelligent gentleman, a very good lawyer. He sees the problem in the accidental admission, and so he tries for an escape route. His claim now is, no, I was just notifying, I was indicating that I would notify the DA's office about what I intended to do. Except, Judge, that's not what he said. He said, I can't decide until I meet with them and we discuss our various options. That doesn't sound like informing anybody of anything. Certainly doesn't sound like informing anybody of a decision that's already been made. I think the court would agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table. Let's talk about strategy. Then, Judge, I'll get back to you. Mr. Cosgrove actually showed us what's really going on behind the closed doors that we suspected all along. So who's really advancing this case? Maya Angelou once said, when someone shows you who they really are, believe them the first time. That is a poignant and pointed statement that I refer the court to just to say, if someone says something in an unguarded moment, you got to sort of put some stock into it. You got to believe them.
What are you looking to disqualify Mr. Cosgrove from? Any involvement in the Reed cell phone issue?
Yes.
Or also, I mean, you shouldn't, do you believe that you have standing in the case of Commonwealth versus Adam Carney?
So that's a very good question, and I wrote in my notes. The judge is going to ask you, what do you want me to disqualify him from?
It was pretty good.
That is the question. It really is, Judge. Yes. In answer to your question pointedly, he should not, Mr. Cosgrove, and like I said, seems like a kind gentleman, very good lawyer, but he cannot advance the case having anything to do with Karen Reed. Why? Because the investigation, as it is, for whatever that investigation is, the only insight I have, the only crystal ball I can rub, has something to do with this search warrant. So he should have nothing to do with advancing the search warrant. He should be removed altogether because the DA's office is removed altogether. And if, in fact, to answer the next question the court might have, if, in fact, there's another special prosecutor that were to be assigned to this case, God forbid, to complicate matters more, that person should have no communication, no contact with Mr. Cosgrove, nor the Norfolk County District Attorney's Office.
And who should appoint that person?
That's the $64,000 question, Judge. I don't believe that person can be appointed. I believe that this has run its course and that the District Attorney's Office was supposed to do what it wished to do by hiring an independent special prosecutor. Unfortunately, that independence was magnificently breached, not in a small way, in a big way, in the biggest of ways. And so I think the District Attorney's Office is not in a position to say, okay, well, I'll do it again. I'll take a mulligan on the first one, and I'll do it again and appoint a second special prosecutor. That search warrant should be dead on arrival because Judge Krupp said the phone has to be returned. The only reason that Mr. Cosgrove is even following this thread, pulling this thread, is in no small part. As a matter of fact, I would say it's in almost total part, because the Norfolk County District Attorney's Office did not want that phone returned.
Okay, let me call upon Mr. Cosgrove.
Of course.
Yeah, Mr. Cosgrove, go right ahead, sir.
Well, Your Honor, let me begin where Mr. Jackson began with the discussion of standing. And Mr. Jackson made a wonderful argument that his client had standing to litigate the possession of her telephone. He made a terrific argument that she has standing to challenge the search warrant, but I heard no argument as to what standing she has to raise the alleged conflict of independent counsel, because there is no conflict. Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor, with the one exception of the special prosecutor for the second trial, Mr. Brennan, who worked hand in glove with the personnel from the DA's office. So it seems to me, Your Honor, that Ms. Reed has no standing because there is no conflict. Even if I were consulting with the DA's office on my every move, which I am not, I don't see that there would be a problem. I have yet to hear what Mr. Morrissey's personal interest or conflict is in this case. It was represented in the papers that were filed that he was a victim, and I heard Mr. Jackson describe him as a self-described victim. I can use the word described twice in one sentence. I don't know when or where or if he actually made that statement or what the context was. But certainly there has been no indictment that I am aware of or charge or whatever listing Mr. Morrissey as a victim in any way of this case. I have to say that as I listen to Mr. Jackson recharacterize my comments, I can't make that decision. I can't decide that. They do seem quite damning. The only problem is those aren't the comments that I made. I made the comments that I made. They're a matter of record. They were quoted in the initial filing. They were quoted in my filing. I submitted an affidavit explaining what actually happened. Credibility of that affidavit is, of course, for your honor, and I'm not going to argue it. I will only say about Pisa and Ellis that if your honor looks at the facts of those two cases, they are totally divorced from anything that's before your honor today.
What was the issue with Ellis? I just read Pisa when Mr. Jackson quoted it. What was the issue on Ellis, the recusal?
If I remember it correctly, your honor, it's been a while since I've read it. It had to do with some illegal behavior by police officers that the district attorney was involved with. But I apologize for not being more on top of it, but I will take a look at it, and if you wish, file something.
I'll read the case, but I was just curious.
I do want to comment on Mr. Jackson's response to your honor's question, which he apparently was well prepared for and anticipated. Are you asking me to disqualify Mr. Cosgrove on the Kearney case or just on this matter? And I think the correct answer, your honor, is it really doesn't make any difference, because if your honor finds that I have an ethical conflict of interest and can't serve in this case, I think that counsel for Mr. Kearney will be in court tomorrow morning waiving your decision, saying the Commonwealth has had a full and fair chance to argue the situation and it should be applied res judicata. So I think that's going to be the bottom line, one way or the other. Right. Finally, your honor, I'd like to comment on the credibility of the other side in this case. My attention was recently given to a video recording of the March 18th, 2025 second trial of Karen Reed. And I observed the video on the internet. Therein, a justice of this court made the following oral findings, and I'm going to quote them, and I'll submit an affidavit upon the completion of doing so, because I'm going to skip over a lot of factual details that aren't particularly relevant here. In open court, Judge Cannoni said, based on all the evidence, I conclude that the candor required by all lawyers has not been demonstrated here. I find there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. They were made in sidebar, in open court, and in pleadings. And after going through some of the details, she says, I find that there was a material misrepresentation and that it was deliberate. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. Those comments were made with respect to Mr. Jackson and the colleagues from his firm who filed the motion and affidavit and did the oral argument before the court today. And I would ask the court to consider that finding with respect to the credibility of the defense findings. And I will close with the words of Mr. Jackson: when someone shows you who they are, believe them the first time. I'll submit this to the clerk, and I have a copy for you.
Thank you.
Sure.
Yeah, just grab me the book. All right. Mr. Jackson, I take it by the fact that you've risen that you wish to respond in some way.
I would like, very briefly,
No, go ahead.
to speak to a couple of issues. I find it rich that a member of the bar who doesn't like what his own facts represent decides to take a personal shot at opposing counsel. That's I think that's beneath Mr. Cosgrove's dignity. It's certainly beneath the court's dignity. The court doesn't have any idea, because it wasn't sitting in the courtroom along with Judge Cannoni, what the circumstances of those comments were. And certainly Mr. Cosgrove has absolutely equally no idea what those comments were. And it's offensive, but it also is very telling. It's extraordinarily transparent. If you don't have the facts on your side, then you argue the law. If you don't have the law on your side, then you argue the facts. And if you don't have the law on your side or the facts on your side, just attack opposing counsel.
I thought you were supposed to bang the table.
I think so. Exactly.
That was what it was.
Try to make it as loud as you can. And
Yeah.
with
That was
his
the old
words-
saying, anyway.
Yes, exactly. And I think everybody in the courtroom can see that. It's a little bit of an act of desperation. And I appreciate the cleverness and the desperation that Mr. Cosgrove shows, but it is of no legal moment for why we're here today. So no, to answer the court, once again, I am not suggesting I take no position on Mr. Cosgrove's further investigation or prosecution as it relates to Aiden Carney. That is not my position. He is not my client. But what I am concerned with is his position in terms of the search warrant and any further investigation into Karen Reed. And I find it almost nearly shocking, if I can use that word, that Mr. Cosgrove would stand up and say, there's no conflict.
Go right ahead.
Even were I to consistently consult with the Norfolk County District Attorney's Office, that would represent no harm. There's no big deal. Your Honor, if it was no big deal that he consult with the conflicted Norfolk County District Attorney's Office over the issues attendant to witness intimidation that is focused on Aiden Carney and concomitantly focused on Karen Reed because of what he says may have been an agreement between and among them, then the question is begged, why was he ever appointed in the first place? If there's no issue with conflict, why was he appointed? Why is he getting paid taxpayer dollars? He was appointed because Mr. Morrissey recognized that there was a potential conflict because Mr. Morrissey is a titular victim, a potential victim of the very allegations he's investigating. And now Mr. Cosgrove is proverbially in bed and has been with the district attorney's office. That's the issue that we've got. And Mr. Cosgrove's affidavit is equally flawed as his reasoning on that argument. His affidavit does not cure the problem. His affidavit is the problem. Consider what it actually offers. It's a sworn assurance from the very person whose assurance of independence is in question by his own words. The court doesn't have to find, and I'm going to step up a little bit from the personal attacks and invectives. I don't think they're appropriate in the courtroom, and I'm not going to lower myself to engaging in those. The court doesn't have to find, at the end of the day, that there was actual prejudice or that there is actual prejudice against Ms. Reed or her interests. The court does not have to find that there's actual bad faith on the part of Mr. Cosgrove. Neither does the court or neither does the law require that the court find that anyone lied or anybody was mendacious. I'm not suggesting that. And the court doesn't have to find it. Or that he, in fact, made any decision that was on its face corrupt or conflicted. The court doesn't have to find any of that. The law is very clear, Judge, and that's why we're standing before you. It requires one thing. It requires independence in fact and in appearance, and that has been breached. By his own words, the special prosecutor, Mr. Cosgrove, has indicated that the appearance of independence is gone. And for those reasons, the only remedy as it pertains to Ms. Reed's interests is to disqualify him from any further contact or connection with the search warrant and any investigation related to witness intimidation.
Okay.
Thank you.
Thank you very much. Thank you all for being here. I'll take it under advisement.
Thank you, Your Honor.
Thank you.
Appreciate the time.
Thank you, Your Honor. I'll go on. I think that's it.
Whoa, all right.
So you get.
Yeah. Yeah.
God save us from the Commonwealth. God save us from the Commonwealth. Mendacious. Hold on, because you guys want to see AJ, right? Do his thing. Grant was streaming, and I think he got kind of I don't know what his audio was like, but let me just. Oh, it's very, very low. I don't know if we can even really hear it. I did see a mainstream camera in there. They may just put it up later. I don't know. Wow, just wow. What a day, huh? What a day. That was awesome. Well, I thought this hearing was going to have to do with the return of Karen's phones, but it seems that it's turned into something else. Thank you, Vicki Andrews, for your 10. Doolin is amazing. And Babes Mom, thank you for gifting 5. Alan Jackson's in town. He ain't got no quit. And the second half of Proctor's deposition is supposed to be tomorrow. So I don't know if that's why he's here, because I don't really think that's happening. But because this is under a secret docket number, we don't have any of the papers. We don't have any of the papers. This was supposed to be another hearing about Karen Reed getting her phones back. And in my opinion, because Cosgrove failed to file an appeal or a notice of appeal within 30 days, she should have just received her phones back. They should just give them back. It's been a long time. I think he said the last hearing was in February. But what it seems happened here, using my context clues, seems that Alan Jackson's team on behalf of Karen Reed made a motion that to get Cosgrove off the case, that Cosgrove should be disqualified. And the main argument for that was because he's supposed to be an independent prosecutor. He's a special prosecutor. He's supposed to be special because Michael Morrissey is conflicted off of this case. And that's the reason Cosgrove was hired at taxpayer expense. And I said this last time. I said, why is Cosgrove saying he's got to go talk to Michael Morrissey? He's not supposed to be talking to Michael Morrissey at all. He's supposed to be independent. And then the argument was, well, you don't have standing because this is really made in Aiden Carney's case. We don't know because it's made under a search warrant number. And I thought the search warrant had to do with searching Karen Reed's phones because they only had a search warrant that Tully drafted to seize Karen Reed's phone in January of 2024. 2 of them, I think it's on body cam. The body cam is around of them going into Karen Reed's house in January of 2024, taking 2 of her cell phones. And there's some discrepancy about what she says on the body cam about wiping her phone or something. I don't really remember. That's the body cam I'm referring to. And as far as we know, Cosgrove was like, I don't know if we ever searched the phones. We've had them. There was some issue about whether they had to jailbreak them because she wouldn't give them the password. And Cosgrove is arguing that Karen Reed's team doesn't have standing, that only Aiden Carney has standing. And AJ's like, yeah, no, they're her phones. These are her phones. I don't understand why they just can't decide to give her back the phones because there's been no appeal. So without seeing the papers, it's hard to determine exactly what was filed, but it seems to me like they filed a motion to disqualify Cosgrove because he's been talking to Marcy and he's not supposed to be. He's supposed to be a special prosecutor. Let me just hear Grant's sound. It's not great, and the camera's a little wonky. Hold on, let me see this. That was wild. That was wild that AJ said, quoting, breaks out some a Maya Angelou quote. When someone shows you who they are, believe them the first time, because Cosgrove said all of those things. We are going to search the phones. Oh, I need to sit down with Michael Marcy. I need to talk to Michael Marcy. He's like, they should not be talking to each other. And I said that the first time. He talked about rubbing a crystal ball. He talked about the search. He said the search warrant should be DOA. Krupp said, return the phones. And I agree with that. Return the phones. Cosgrove didn't file a notice of appeal. He doesn't know anything about deadlines. That's the thing. And then Cosgrove gets up and says, Reed has no standing because there's no conflict. Because even if I was talking to Michael Marcy, I don't see the problem. And everyone who's an attorney or has practiced law or who works in a law firm's head popped off and is all the way in Canada at this point. And then he pulls out Judge Cannoni's grave concerns speech from March 18th of 2025 at the second trial. And he throws it out there that Judge Cannoni said that she had he didn't say grave concerns, but we know what this was from, that candor to the court is of utmost importance, and that Mr. Jackson and the defense team have made repeated deliberate misrepresentations to the court, pulling that out as if it's fact, and that the judge actually pulled a book off of the bookshelf behind him at one point and started looking up a case. Was he really even paying attention to what they were saying? I don't know. And then threw Alan Jackson's words back at him. I mean, listen, good on Cosgrove for thinking on his feet. And he said, as Mr. Jackson told you, when someone shows you who they are, believe them the first time. And then Alan Jackson got back up and he said, that's rich. That's rich. Yeah, Grant has it. Wait, is Grant live? Law Girls Not Attorneys has a better feed. Grant's is a little bit shaky, so let's go there for a second. If you're just tuning in, we can rewatch a little bit. And then he tried to say, if the facts aren't on your side, pound the law. If the law isn't on your side, pound the facts. And if none of it is on your side, pound the table. But he kind of mixed that up a little bit. And he said, if there's no conflict with Marcy, then why is Cosgrove even here at taxpayer expense and being paid all this money? He said Marcy is a titular victim. There's something in the papers about Marcy being a victim. And we were all like, Marcy's not a victim. Why is Marcy a victim? And he said something like, he said that Cosgrove is and has been in bed with Marcy. It's like, I don't think there's anything mendacious going on here, but this is a problem. It's a problem. Law Girls Not Attorneys had it in a vertical orientation. Let's take a look so we can see at least Alan Jackson's back and listen to what he was saying. Again. Effing again. All right. Let me see if I can make this a little bit bigger. Maybe boost the volume. Shout out to Law Girls Not Attorneys.
The very office that was the subject of the conflict, and that's the problem. It's not a good look.
All right. Is that okay? Is the volume okay for you? Good. All right. We're going to watch this again. Effing again, because it was too good. And we didn't get to see Alan at all. At all. All right. Here we go.
For the purpose of talking about the file, I'm trying not to be repetitive, but I do want to address the no small part of the opposition that the Commonwealth has filed. And really, our motion comes down to a single promise and a single breach of that promise. The promise was independence. That's how we got it. Mr. Cosgrove was appointed on the promise of complete independence from the Norfolk County District Attorney's Office. And on February 19th, in this courtroom, the special prosecutor, I think, slipped and admitted in his own words that the promise had been broken. Everything else in the Commonwealth's opposition, as I read it, is an effort to sort of talk past that fact. And I want to address that in no small part.
I know it's a little garbled, but there's nothing I can do about it because that's what the YouTube booster does. We're sitting in court, Law Girls Not Attorneys, sitting in court. They got permission to live stream it And I guess they were doing it on their phone. But you see the guy right here to the right of the screen with the big giant camera. Looks to me like that's the equipment of WBZ or something. But this turned out to be some real fireworks. And AJ's not playing. He's not playing. That's why he gets the big bucks.
In some work, and I will start with the standing issue. That's where the Commonwealth leads in their opposition, and I will lead in my response to that opposition. The Commonwealth's lead argument is basically the conflict, in as much as it might exist, it belongs to Aiden Kearney, not to Karen Reed. It's a clever argument, and again, Mr. Cosgrove for leading with that, because it is clever, but it's also wrong. The warrant doesn't exist in the abstract. It exists because the Commonwealth has advanced a theory, a state theory on the record, that basically Karen Reed potentially engaged in some sort of witness intimidation. That's the foundation of what the
That is why they seized her phones, because they wanted to try and prove that Karen and Aiden were conspiring to commit witness intimidation. Yes, the Reeds were there today, Karen and her parents. Yes.
Commonwealth has suggested precipitated the war in the first place. And it's on the strength of that, what we believe is a very flawed and a false theory. They went to a judge in the court and they said, we need a warrant naming her, Karen Reed, and they seized her phones. And today, this is what the special prosecutor is actively litigating to keep her phone away from her, out of her possession. So in terms of standing, when the Commonwealth stands up and says, Karen Reed is basically a stranger to this conflict, she has no standing, this is Aiden Kearney's conflict, that's simply not true. I've asked the court to inquire a few questions of Mr. Cosgrove. Whose phone is it that's an issue? Whose name is on the warrant? Whose privacy is on that device? That's not Karen Reed borrowing Mr. Kearney's grievance. That's Karen Reed asserting in the most direct way that she possibly can her own interests that the law recognizes.
Yeah, it's her phones. She's got the right to come in. She has standing. It's her property. Thank you, Josie Lou, for gifting 10 memberships. You're amazing. And to those of you who are randomly gifted, welcome. It's her property. She's got standing. It seems basic, but sometimes, I wonder about Cosgrove and his arguments, because sometimes he has nothing. Like, I think he really just has nothing. And so he came out with the ridiculous quote from Judge Cannoni as if it was the truth.
It's in her property, which the government sees, and is improperly held. The legal standards and why we're here. Let's be clear about what the governing law is at the outset. Because the entire Commonwealth's opposition depends on the court and in hopes of the court applying the wrong legal standard, which I'm sure it is not want to do. The right things in place, with the right words in place, the entire argument by the Commonwealth falters. The rule for prosecutorial disqualification, and I say that with an emphasis on the word prosecutorial, because I'm going to get to a point that Mr. Cosgrove cites in his moving papers that it's incorrect citation and incorrect application of the law. The rule for prosecutorial disqualification in this Commonwealth is told to us by a couple of cases that we cited in the moving papers that the court has in front of it, PISA and Ellis. And it's not ambiguous in the weeks. PISA versus PISA versus Commonwealth deals with prosecutorial conflicts of interest that are treated with absolute strictness. And the words matter. No.
Words matter. That is the case that the judge pulled the book off the shelf behind. How odd is it that the book, coincidentally, with this exact case, and it happens to be directly behind the judge's head? I mean, that's wild to me. Was it a prop? Do they have a prop department? Did somebody put the book there on purpose just in case he wanted to look up the case? Huh.
Showing of prejudice is necessary by Ms. Reed at all. The court does not weigh whether actual harm resulted. It does not weigh whether actual prejudice exists. We don't have to show any of that. The law does not ask whether the conflicted party, in fact, changed any outcome. We don't have to show that an Ellis completes that rule by saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interests, in fact, or, and this is the big one, in appearance. It's those two words that
Yes, they have to avoid the appearance of impropriety. You don't have to show prejudice. You don't have to show factually, but it's the appearance of impropriety. And based on what Cosgrove said at that hearing in February, I got to go talk to Marcy. We're going to get together. We. There should be no we in special prosecutor. You should not be talking to the district attorney's office because the reason the district attorney hired you is because he has a conflict. Do you see how that works? Thank you, Noted 3, for gifting 5 memberships. You're amazing.
I will focus on for a quick second. In appearance, that phrase is the whole case. The law does not ask whether the special prosecutor, whether Mr. Cosgrove was actually influenced by Mr. Morrissey or anybody else in the Norfolk County District Attorney's Office. It asks very simply whether the public, looking at this arrangement, can have utter confidence that he was not in any way influenced by the DA's office. In other words, the law asks very, very clean questions, and the answer is very clearly as clean. It is no. The public cannot have that confidence. And I ask that the court to just hold that law in the back of its mind for a second as I talk about the next point of the argument, which is the actual indication, the evidence of the breach of that promise. And this is because of the facts of the case. There's a breach because of the facts are not very friendly to Mr. Cosgrove's position. And they're also not in dispute because they came right out of the special prosecutor's mouth. On February 19th, from the podium, Attorney Cosgrove told the court that he would basically sit down with the district attorney's office. He was going to go through all of their options. They would weigh the pros and cons of all their options and discuss those pros and cons, and then get back to the court in due course. His actual language is this, and I'll quote, quote, I'd like to take some time to look at Judge Krupp's decision and to meet with the district attorney's office, Norfolk County District Attorney's Office.
I mean, he said that. It's all over YouTube. You can go find it. Cosgrove should have went to find it because he's kind of like, that's not what I said. Alan's going to repeat it word for word. And you know that Alan, I'm sure, listened to it on YouTube and wrote it down. You don't even need to order transcripts anymore. You can just go to YouTube and listen to it.
Quote, I'd like to take some time to look at Judge Krupp's decision and to meet with the district attorney's office, Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss with them our various options. And we are going to, are we going to get the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done that, I'll get back to you as soon as possible. Those personal pronouns and the possessive pronouns used in that phraseology, that paragraph, are not of insignificance. Who is the we? Who is our options? Who's the our in those sentences? Obviously.
Yes, Leah is correct. Cosgrove was Hank Brennan was hired as a special prosecutor not due to conflict. Cosgrove and Mello were both hired because there was a conflict. So yes, it is different. He's not supposed to be having a powwow with Marcy about anything. He's supposed to be independent.
It's in perfect context. It's in Cosgrove and it's the Norfolk District Attorney's Office. In an unscripted and what I would consider to be a pretty unguarded moment, Mr. Cosgrove portrayed exactly what's going on here and who's really prosecuting this case. They're prosecuting a quotation marks, who's advancing or forwarding this case against in terms of the search warrant against Ms. Reed. He's investigating Ms. Reed. They are investigating Ms. Reed. He isn't holding her phone. They are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words. According to Mr. Cosgrove, he could not and was unwilling to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Ms. Reed's phone unless and until he met with the district attorney's office. He explained on the record what needed to happen before he could make that decision. I'll just keep it very quickly. Are we going to get this Reed cell phone back? Well, the unanswered part of that question is, I can't make that decision, Judge, without speaking to the DA's office to find out clearly.
Right.
Number two, are we going to move for reconsideration? Who's we? Well, the district attorney's office. That's who he's referring to. The only answer to that question is, I don't know. I have to check the DA. The third question was posed, are we going to file a notice of appeal? Again, the unspoken answer was, I can't decide that, Judge, not today, because I need to first sit down with the DA's office and figure out what our various options are. It couldn't be any clearer. This is with the completely walled off Norfolk District Attorney's office.
Right.
The conflicted office, the office headed by an alleged.
They used to call it a Chinese wall. I guess that's not appropriate anymore, so I don't know what they call it now. But you're supposed to build a wall around that person, and you're not supposed to have any contact with them. They're supposed to be totally independent. Deanna says, I think Cosgrove wants out. It kind of sounds like that. Kind of sounds like he's like, this is not what I signed up for. Can you just please just cut me loose? Kind of sounded like that, right? And Doolin does issue his decisions pretty quickly. So, I mean, we should hear something soon. I mean, maybe even by the end of the day, he'll handwrite something on the motion. Maybe eventually we'll even get to see the motion papers. Let's see.
A self-described victim of misread, Mr. Michael Morrison. He was the authority.
He's a victim of Ms. Reed. Michael Marcy says he's a victim of Ms. Reed? I must have missed that press conference. Hold on.
Conflicted office, the office headed by an alleged, a self-described victim of misread, Mr. Michael Morrison. He was the authority Mr. Cosgrove admitted he needed to go to before he could make any other decisions. And there's no other way to read these words. The fact is, he's not authorized, obviously not authorized to make a strategic decision about misreading the phones until he got prior approval from the very office that was the subject of the conflict. And that's the problem. It's not a good look for the DA's office. It's not a good look for the Commonwealth. It's not a good look for Mr. Cosgrove. And appearance, when I use those words guardedly, it's not a good look because appearance means everything in this case, as we'll see. So Mr. Cosgrove, in his living papers, he sees the problem, obviously. He's a very intelligent gentleman, very good lawyer. He sees the problem of the accidental admission, and so he tries to escape from it. His claim now is, no, I was just notified. I was indicating that I was notified the DA's office about what I intended to. Except, Judge, that's not what he said. He said, I can't decide until I meet with him and we discuss our various options. That doesn't sound like informing anybody of anything. Certainly doesn't sound like informing anybody of a decision that's already been made. I think we'll agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table. Let's talk about strategy. Then, Judge, I'll get back to you. Mr. Cosgrove actually showed us what's really going on behind closed doors that we suspected all along. So who's really advancing this case? Maya Angelou once said, when someone shows you who they really are, believe them the first time.
It's Maya Angelou. Cosgrove is going to throw that back at him. Thinks he's clever.
That is a pointed statement. Before the court to just the setting. If someone says something in an unguarded moment, that sort of puts the stop on it. You got to believe.
What do you look at this long like Mr. Cosgrove any involvement in the Reed cell phone issue?
Yes.
Or also, do you believe we have standing in that case of Commonwealth racist County?
So that's a very good question. I wrote my notes. The judge is going to ask you what do you want me to process. That is the question. It really is. Yes. In answer to your question, he should not, Mr. Cosgrove. Like I said, he's a kind gentleman, very good lawyer, but he cannot advance the case having anything to do with character. Why? Because the investigation, as it is, whatever that investigation is, the only insight I have, the only crystal ball I can run, has something to do with this search. So he should have nothing to do with advancing the search warrant. He should be removed altogether because the DA's office is removed altogether. And if in fact, to answer the next question the court might have, if in fact there's another special prosecutor that would be assigned in this case, God forbid, to complicate matters more, that person should have no communication, no contact with Mr. Cosgrove, nor the Norfolk County District Attorney's Office.
Who should appoint that?
That's the 64,000.
Who should appoint that person? He says that's the $64,000 question. Some people in the chat were like, why did he say 64,000? That's such a specific number. Because there was an old time game show called the $64,000 question, right? Back in the day, a really old game show, like maybe in the 70s. Yeah, who's going to appoint that person? Exactly. How about just give it the damn phones back? Didn't the O'Keefes try and intervene in this action, trying to say we want the phones? And judge said, no, you're not getting them. Why not just give the phone back? The phones, instead of going through all the trouble to get Cosgrove off the case. I don't know.
I don't believe that person can be appointed. I believe that this has run its course, and the district attorney's office was supposed to do what it wished to do by hiring an independent special prosecutor. Unfortunately, that independence was magnificently breached, not in a small way, in a big way, in the biggest of the ways. And so I think the district attorney's office is not in a position to say, okay, well, I'll do it again. I'll take the mulligan on the first one, and I'll do it again and appoint a second special prosecutor. That search warrant should be dead on arrival because Judge Krupp said the phone has to be returned. And only reason that Mr. Cosgrove has been following this thread, pulling this thread, is in no small part. As a matter of fact, I would say it's the almost total part, because the Norfolk County District Attorney's Office did not want that phone returned.
Okay, let me come up with this.
Of course.
Okay, here comes Cosgrove. I feel like it took him a while to get up. Oh, is he not? Is he going to go to the podium, or is he going to stand with his back to Alan? Oh, he's going to go to the podium. Nice orange tie. Is that an orange tie today? All right, he's got a little goatee working. Kazi G with the goatee.
Well, Your Honor, one thing you did when Mr. Jackson began with the discussion of standing. And Mr. Jackson made a wonderful argument that his client has standing to litigate the possession of the telephone. He made a terrific argument that she has standing to challenge the search warrant. But I heard no argument as to what standing she has to raise the alleged conflict with independent counsel, because there is no conflict. Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor.
He's saying there's no conflict for Karen Reed because there were 2 trials. She suffered through 2 trials. He didn't say suffered through. Those are my words. Without a special prosecutor. So he doesn't have a conflict as to Karen Reed. Michael Marcy doesn't. And so it doesn't really matter. Nathan said the court order for O'Keefe case says that the phones have to be preserved if they're released back to Karen. Right. Right. And yes, the phones were already ordered to be given back, except the Commonwealth was able to hold on to them through appeals. And I don't know that they ever filed a notice of appeal because nobody ever mentioned that at all during this hearing.
With one exception of special prosecutor for the second trial, Mr. Graham, who worked hand in glove with the person from the DA's office.
Right, because there was no conflict. Michael Marcy hired Hank Brennan for reasons unknown, maybe because he needed a mob lawyer, because it's very similar to, you know, fighting the mob in this case. If you know, you know.
So it seems to me, Your Honor, that Ms. Reed has an understanding because there is no conflict. Even if I were consulting with the DA's office, which I am not, I don't see that there would be a problem. I did get to hear whether Marcy's personal interest or conflict is in this case. Was represented in the papers that were filed when he was a victim. And Mr. Jackson described him as a self-described victim. That means the word described twice in one sentence. I don't know when or where or if he actually made that statement or what the context was. But certainly, there has been no indictment that I am aware of, or charge, or whatever, listing Mr. Morrissey as a victim of this case.
If you're not liking the sound on this version of the hearing, you can rewind and watch the Zoom version. The sound is much cleaner. We're watching this version because we want to see the attorneys, and the Zoom version only focused on Judge Doolin. Also important to point out that Robert Cosgrove is a judge. He's a retired judge from, wait for it, Norfolk County. He's a retired judge. Came out of retirement for this, I think. That's why Howie Carr calls him Triple Dip Cosgrove, because he's got 3 pensions working. 3 pensions.
I have to say that as I listened to Mr. Jackson recharacterize my comments, I can't make that decision. I can't decide. It is seem quite clear. The only problem is those aren't the comments that I made. I made the comments that I made. They're a matter of record. And they were quoted in the initial filing. They were quoted in my filing. Submitted an affidavit explaining what actually happened. Credibility of that affidavit is, of course, in your honor, and I'm not going to argue with it.
I'm going to just speed him up a bit because he does speak really slowly.
I will only say about piece of analysis that if your honor looks at the facts of those cases, those 2 cases, they are totally divorced from anything that's before your honor's bench. What was the issue with Alice? I just...
He's wearing sneakers. I think he's wearing sneakers. Does he also carry a backpack? You can bet your ass that Alan Jackson is not carrying a backpack, okay?
Read a piece of when Mr. Jackson quoted. What was the issue with Alice? If I remember correctly, Your Honor, it's been a while since I've read it. It had to do with some illegal behavior by police officers the district attorney was involved with. But I apologize. I'm not being more competent. I would take a look at it in the response. I'll read the case, but it was I do want to comment on Mr. Jackson's response to Your Honor's question, which you actually was well prepared for and anticipated. Are you asking me to?
Okay, if your mind has started to wander because you're falling asleep during his speech, listen up now, because now is when he's going to pull Judge Cannoni's grave concerns speech out and say, well, she had grave concerns about Mr. Jackson and their ability to, follow the rules of ethics, and you should too.
Disqualified supervisor on the pretty case or just on this matter. And I think the correct answer, Your Honor, is it really doesn't make any difference. Because if Your Honor finds that I have an ethical conflict of interest and can't serve in this case, I think that counsel for Mr. Curry will be in court tomorrow morning, waiting your decision, saying the Commonwealth has had a full and fair chance to argue the situation and it should apply very strictly about it. So I think that's going to be the bottom one way there. Finally, I'd like to comment on the credibility of the other side of this case. My attention was recently given to a video recording from March 18th, 2025
You were recently, he says, I was recently given a video recording of the March 18th, 2025 trial of Karen Reed. Who's helping him behind the scenes? Who do you think? I don't know. Any guesses? Who do you think's helping him behind the scenes? Somebody sent him the video.
Second trial, my attention was recently given to a video recording from March 18th, 2025.
My attention was recently given to a video recording.
The trial of Karen Reed. I observed the video of the incident. There in the justice of this court, they following oral findings, and I would quote them. And I'll submit an affidavit upon the completion of doing so, because I'm going to skip over a lot of factual details that I'm clear of. In open court, Judge Cannoni said, based on all the evidence, I conclude that the candor required by all lawyers has not been demonstrated. I find there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were made in sidebar, in open court, and in pleadings. And after going through some of the details, she says, I find that there was a material misrepresentation and that it was deliberate. Candor with the court is essentially the bedrock obligation of all lawyers to appear in this court and all courts in Massachusetts. Those comments were made with respect to Mr. Jackson and colleagues from his firm. We filed a motion and affidavit in the oral argument.
It has nothing to do with this hearing stuff. It has to do with you shouldn't believe anything Mr. Jackson says because look at what Judge Cannoni says about him. And we can't see Alan's face from this POV, but okay, Sassy Desk Diaries. I don't think I'm liked on this channel. Why would you think you're not liked? And I'm not sure why. It's kind of sad as I've been watching Melanie since the first trial. I've always been kind to her. Who said I didn't like you? Don't believe anything you read on the internet. I love you with all of my heart. Why would you even say such a thing? Now you hurt my feelings. What are you talking about? All right, let's watch Alan's face.
Mr. Jackson and colleagues from his firm, we filed a motion and affidavit in the oral argument before the court today. And I would ask the court to consider that finding with respect to the credibility of the defense's findings. And I will close with the words of Mr. Jackson. When someone shows you who they are, believe them the first.
What? He's like, that's rich. That's rich.
Mr. Jackson, I think about the fact that I would like to speak to one of the issues. I find it rich that a Mr. Barr, who doesn't like his own facts represent, decides to take a personal shot at the opposing counsel. That's I think that's beneath trial court's dignity, certainly court's dignity. The court doesn't have any idea because he wasn't sitting in circumstances those comments were. Certainly, Mr. Cosgrove has absolutely no idea what those comments were. That it's offensive, but it also is very telling. It's extraordinary transparent. If you don't have the facts on your side, then you argue the law. If you don't have the law on your side, then you argue the facts. If you don't have the law on your side or the facts on your side, just attack the opposing counsel. I think
And this is where the sound goes off. So we're just gonna, if you want to hear the rest of this, you can rewind, listen to the Zoom. If you want to hear what Cosgrove actually said in February, I have that pulled up, but let me get to some of these super chats because I think that's where Sassy Desk Diaries was not feeling happy because I haven't read it yet because I didn't get there yet. Hang on. GB Packer fan says, can we go to that hearing to see what Cosgrove said? We'll take a vote because I also want to do the Lindsay Clancy final pretrial hearing. So we got a full docket today. So if you guys want to see it, we can see it. It's not a very long hearing. It is a pretty quick hearing. Denise says, happy 3 years. Oh, it's been a great journey here. Thank you for your 10. Caesar says, YouTube unmembered me. Grr, I just rejoined. Hopefully I get all my time back. It was well over 30. Honey, I don't know how that works. I don't know how that works. Thanks for tuning in from Canada. I think I don't know. If your credit card expires, maybe it doesn't renew your membership. I don't know. I genuinely don't know, but I hope you do too. You can always reach out to YouTube. I think that they're very, I think that you can chat with them or something. I really don't know. I'm not like a technical person. Cat Q says, don't they read the docket number at the start of the hearing? They read some search warrant number, but again, you can't look that up in the court computer because it's not public. I think they did read a number, but it was a search warrant number. Someone suggested getting case number from what the clerk announced. Yeah, again, I don't think you can find it. If anybody can find it, let me know. I put this up earlier where you said you appreciate me, Sassy Desk Diaries, and thank you for your 10, which I didn't get to yet, from 321. And now it is 349. I apologize. I wanted to say you're beautiful and I appreciate all you do. I appreciate you too. Thank you so much. Joey Three Sticks, thank you for your 10. Says Norfolk County residents, make sure to vote in the September 1st primary for Norfolk County District Attorney. That's right. That's the primary. And I think whoever wins that primary is the district attorney. I don't know. That's what they tell me. That's what they tell me. Gavel and Gaslight says Cosgrove entered the hearing citing Karen's second trial. He wasn't defending himself. He didn't know what AJ would say. Instead, he came in with a personal attack that he intended to use. Yeah, I think so. Kathleen, were you in court today? Kathleen says when Karen walked out of the courtroom, I heard Kate Peter ask Karen why she factory reset her phone. Was Kate Peter there too? I know that some of you guys had boots on the ground today in the courtroom. Tell me everything. I think we can take this. I think we can take slow mode off now, since we've quieted down a little bit. So I was curious about that. Aunt BB says if Doolin removes Cosgrove, won't they just appoint another special prosecutor? Yeah, but who's going to do it? Marcy can't do it because he has a conflict. No other county wants to touch this, right? Because we've seen this film before, right? And that was the same argument that Aiden made when trying to get Cosgrove disqualified, was that no other county wants to touch this. They tried to get the feds to do it because there's some emails that surfaced about that where Michael Marcy was begging, I forget who, Leah Foley or somebody, to prosecute Aiden Carney. And they were like, no, we're not doing that. And so I don't think any of the other counties want to do it either. And so it's a problem. Who would do it? That's the problem. They're doing everything to stall, Aunt BB says, because in my opinion, if they turn the phones over, they lose the opportunity to continue searching for the password. Thank you, Mel. Thank you, Aunt BB. Yellow Ledbetter says AJ should have had Auntie Deb come in just to read that Maya quote in his Maya voice. Ha ha ha. Great day with Dylan. Love him. Thank you. Grace Face says, how was AJ's credibility even at issue here? He was arguing based on Cosgrove's own word in case. Exactly. It was an ad hominem attack on another attorney, which is something that most attorneys who are classy wouldn't do in court. But when you have nothing else, remember, we have a whole background for that. Hold on. Where is it? Socrates said, when the debate is lost, slander becomes the tool of the loser. Right? That's it, Grace Base. That's what it is. When the debate is lost, slander becomes the tool of the loser. Desiderata, catching up. Happy tears, the fight. AJ gives Karen. Yeah, who knows what Judge Doolin's going to do with this, but I love Judge Doolin. So we'll hope he does the right thing. Overruled, sit down. Says there's no way he's going to argue in Boston in a half an hour. That's not today. That's tomorrow. So I'm not sure. Are you saying he only has half an hour for an argument tomorrow in federal court? That's right. Tomorrow is the anti-SLAPP motion to dismiss in Plymouth in the morning at 10 a.m. with Judge Gilday. And then in federal court in the afternoon at 3 p.m. where there are no courtrooms. PD10, thanks for your 10. My first super chat ever goes to you. Oh, Melanie, you're amazing. Thank you so much. That was really, really, really very sweet. Holland, thank you for your Venmo. Says thanks for what you do. Thank you. Anne says great overview. Thank you, Anne. Jennifer, can you keep an eye on the Wellesley murder? James Floyd Bennett III. Okay, I'll take a look into it. April says happy anniversary and thanks for all that you do. You're the reason we all stay sane in these crazy times. Thank you. And Susanna said I brighten her day. And Lisa just said, I'm awesome. Thank you, Melanie, for your cash app. Oh, that's very sweet. She said, I'm so glad I found you. All right. What do you want to do next, folks? Tomorrow is kind of a, oh, this is kind of funny. Tomorrow's kind of a crapshoot. Tomorrow's a crapshoot because I have a colonoscopy in the morning, but it's really, really, really early in the morning. But you know, it's just routine. Like you have to get them done. Just go get them done. All right. To do those and do your mammograms because they're important. So by the time the 10 a.m. hearing comes around, who knows if it's even going to be televised tomorrow on the motions to dismiss, the anti-SLAPP motions to dismiss. But it could be interesting because if I'm back and I'm at the camera, it could be funny if I'm coming out of anesthesia. But it's going to be a crapshoot about whether or not that happens. So I'm just giving you a heads up, just in case I'm not here, that you don't freak out that I'm not here, because it just means it took longer to, you know, wake up, or I had to go back to sleep or something like that. So there's that. All right, do you want to see? I'm very sorry. I'm very sorry, KBD, but I don't want to share your sister's diagnosis with the world, and I'm so very sorry. Oh, you're saying it's very important to go get your colonoscopy. Oh, yeah, my prayers are with her. Sending all the healing vibes. No, I didn't start my prep yet. I didn't start my prep yet, which is why I got to get off of here soon. I think I got to start at like 5 or 6. All right, so let's do this. Do you want to look at what Cosgrove said back in February of 20? Propofol. Propofol is like the best nap ever. All right, let's go back to February and see what Cosgrove had to say, and then we're going to Lindsay Clancy. I don't know how long that hearing was, but I think we have time. So let's just go back. This is a guy named Urbellis. Remember Karen's attorney for the return of property first was Steve Buzang, right? Steve Buzang was the attorney. Then she fired him. Then she hired this guy, Urbellis. Karen did. And then I don't know what happened to Urbellis because Alan Jackson was there today for her. So this is February of 2026 hearing. And this is when they first started arguing to get her phones. Well, not even first. It's been going on for a long time. All right. So I may speed it up a little bit because Cosgrove is a slow talker. All right. So here's Mr. Urbellis. I think his name is Ben. Does it recall Benjamin Urbellis? Okay. All right. The colonoscopy talk is over. Okay, I don't want to talk about it. I'm just telling you the reason why. If you don't see me at 10 a.m., don't think I'm blowing you off, because I would never do that. All right. Let's go. All right. Well, I don't want to hear him. I want to hear what Cosgrove has to say, because that's the important part, right? And if you want to, you can go to Trial Channel. This is courtesy of the Trial Channel. And you can watch this hearing for yourself in its entirety. Okay, here comes Cosgrove. Cosgrove.
So, Your Honor, let me just back up a little in the narrative presented to you by Mr. Urbellis. I'm not going to go through all of it, but let me pick it up from Judge Krupp's decision. There were two motions, just to clarify, before Judge Krupp. One was a motion that the defendant filed for return of the cell phone, and the other one was a motion from the Commonwealth to set up a tape team. Ultimately, Judge Krupp wound up denying the motion to set up the tape team. He made no order with respect to the motion to return the cell phone. I got Judge Krupp's decision the same day he issued it. We have a very efficient clerk's office in this court, as you know.
Yes.
So at about 4 o'clock, Judge Krupp's decision appeared in my inbox, and about an hour later, I would estimate, I had Mr. Urbellis's request that Ms. Reed would like her cell phones back as soon as possible, and could he get them on Monday? I replied.
Kathleen is telling me that Urbellis was there today, sitting next to Alan Jackson.
Either that day or the following day, and my reply is, I believe, reproduced exactly in Mr. Urbellis's original motion. I said that we just got Judge Krupp's decision. I'd like to take some time to look at it and to meet with the Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss.
He just said that. I intend to sit down with the Norfolk County District Attorney's Office. And I want to go back and watch my own feed on this because I know I was screaming about it. I'm like, you can't sit down with Michael Morrissey's office. He has a conflict. You're not allowed to talk to him about strategy because you're supposed to be an independent prosecutor. This is exactly what he said. Listen.
I said that we just got Judge Krupp's decision. I'd like to take some time to look at it and to meet with the Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss with them our various options. Are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done...
We. Are we going to do this? Are we going to do that? Are we going to do this? Are we going to do that? No. You're not supposed to be a we. There's no we in special prosecutor. The reason you were hired is because Michael Morrissey has a conflict. You're not supposed to be strategizing anything with him or telling him anything, and he's not supposed to be telling you what to do. Okay, AJ didn't lie. He wouldn't lie. He has access to this too. He went back and watched it.
That within a week or so and discuss with them our various options. Are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done that, I'll get back to you as soon as possible. Apparently, Mr. Abellis having asked me to jump, the only acceptable response was how high, because in response to my response, as he just described, he filed a motion, captioned renewed motion for return of the cell phone before this court. And all
right, well, that's the part that we wanted to hear. So he's not supposed to be working with Morrissey, but clearly that's exactly what he said. And it seems to me that Judge Doolin should and has just cause to disqualify him from all cases now, because he's not supposed to be talking to Morrissey about anything, right? Am I wrong? No, I think I'm right. And he's not supposed to be talking to Morrissey about any strategy or anything, because he's supposed to be independent. That's the whole thing. So there it is. We went back and we made sure that everything that Alan Jackson said was correct, and we heard him just say it for ourselves, right? Right. Villanelle, you're welcome. She says, thanks for making me laugh. U.S. Lily, almost 1 year, proud to be a cupcake. You're great. Oh, thanks, Lily. Music of My Soul says, they only caught the end, but it's amazing to see Alan Jackson in that courtroom again. Those other attorneys, I haven't done well with the phone hearings, in my opinion. Karen's not taking any chances this time. Right. Tammy, thank you for your 10. I appreciate you so much. Edward says, watch Karen's lawyers double take when Cosgrove starts saying we. You guys can rewind. Thank you for your 5. I don't have enough time to go back and rewind everything today, but let me just take a look and see how long Lindsay Clancy's pretrial hearing is to see if we have time to do that today, because Kevin Reddington, I like Kevin Reddington. All right, it looks like it's about an hour. Let's take a vote. You want to do it? You want to watch Lindsay Clancy's pretrial hearing? Anyone? I think we should, right? It's an hour. Might as well get all these hearings in today. Otherwise, we're going to have too much to catch up on. What do I think the outcome will be? I don't know. I would never place money on a judge's decision, like ever. Ever. It feels to me, Patty Smith, that Cosgrove wants to be taken off these cases. Did anybody else get that vibe? Did you get that vibe that Cosgrove wants an out? Right? If I can start drinking. Oh, it's all right. I got time. I feel like Cosgrove wants an out, but I feel like that's a good reason to give him one, because he's not supposed to be strategizing with Michael Morrissey at all. Michael Morrissey's not supposed to be involved. That's the reason they hire a special prosecutor. Okay. All right, let's do it. We are going to now pivot. We are now pivoting to Lindsay Clancy's final pretrial hearing. Jury selection is supposed to start for Lindsay Clancy on the 20th, which is a week from today. I don't know how long it's going to take to pick a jury. But Lindsay Clancy is charged with murdering her 3 little children with exercise bands after sending her husband out for takeout. We read the legal malpractice case. I think it's a good one. She was on many, many, many medications. She tried to get help. Postpartum psychosis, postpartum depression. She jumped out the second-story window. She's now paralyzed from the waist down. It is a tragic story. She does not want to live. Kevin Reddington is her attorney. He has said many, many times, Judge, we need to arrange safe transport for my client to come to court because she does not want to live. And I don't want it on my head, just like you don't want it on your head, that if she takes her own life in this courthouse, I don't want any part of that. I don't want any part of that. It's horrific. Her husband stands by her. Her family stands by her. They say that she was on so many kinds of medication that she didn't know which way is up. She is a nurse. She was a nurse, Lindsay Clancy. And it is a heartbreaking case any way you look at it. Any way you look at it. And we tend to look at things with a little more nuance here than just she's evil, she killed her children. Because, yeah, that is the way I would think everyone who kills their children has something wrong with them. I would submit to you. Sometimes there could be a root cause for all of it. And it's going to be an interesting trial, to say the least. Kevin Reddington, at one time, even he's her defense attorney, he agreed to concede that she did kill her children and to only have a trial on the penalty phase about whether or not she met the legal definition of insanity at the time she committed the acts. It is a horrific, it's going to be horrific. It's going to be weeks long. It's going to be horrific. And I've seen a lot of people out there commenting about it and are not really taking these other factors into consideration. And it kind of makes me sad because both things can be true. You can feel empathy and you can feel horror at the fact that these children are gone. And you can also feel empathy for a woman who was trying to get help. And everyone failed her. So both things can be true, right? Well, at least on my channel, they can. So let's get to it. Let's go into, this is Judge, for the love, I can't remember, is this Judge Sullivan? There's so many judges. All right. Yes, it is true that the Commonwealth has dropped 3 charges. They've dropped the strangulation charges against Lindsay Clancy because they are redundant, because she's being tried for 3 counts of murder as well. And so the strangulation is redundant. And so they have dropped that. Okay. So let's go into today's final pretrial hearing for Lindsay Clancy. And let us see what happened.
The pretrial matters, we're going to go, I want to talk to counsel in regards to if the defendant at some point is going to request to be absent from the courtroom at some point during the trial. I want to go over.
That's not confidence, don't.
No, I know, that's,
I don't know why the booster is not working. Can you hear it okay? Give me a second to refresh this and see if I can get the booster to work. It sounds low to me, but yeah, the trial is going to be televised. Law and Crime is going to be there, Court TV, everybody. They've been talking about this trial for a long time. All right, here we go. What about her phones? The judge did not decide. He's going to take it under advisement. You could hear it? Okay. All right. If the volume is good, then we will let this judge continue.
be absent from the courtroom at some point during the trial. I want to go over.
That's not confidence, don't.
No, I know, that's, I'm just, the reason I wanted to raise it so that if it, and it's not carved in stone, but if it comes
I
up,
can tell you, Your Honor, that without evading attorney-client privilege, she does not intend to seek to absent herself at all from this trial. She'll be here from beginning to end.
and that's fine. The only reason I'm saying it is I know that was raised, it may come up, that's all. And if it comes up, it may come up because of observations I make. I'm not saying that the defendant would be requesting that, but I just kind of wanted to let.
Oops, I just boosted it. Okay, yeah. And they were having a lot of problems getting, there was a lot of problems with transport and how they were going to get Lindsay Clancy to get to the trial every day because she needs an aid. She is paralyzed from the waist down. They have to have special transport. Oh, I'm glad you love your trucker hat. I'm glad. Thanks, okie dokie. And so there were issues about getting her to court. And that's what Reddington was saying. Like, listen, if she takes her life, you don't want this on your head, Judge, and neither do I. Can't get captions on this yet.
Council know how I would handle that if that came up. Then we want to talk just about, and then we've got the blood spatter motion we have to address, I believe.
Your Honor, I've changed course on that, and I've talked to defense counsel about that today. I'm no longer going to, my goal is no longer to use a physical demonstration. During prep with the witness, we realized that a series of photographs might better display the different types of spatter. So the witness is sending me photos that she uses during trainings when she trains other people, and I'll send those to defense counsel, and we should be able to agree on some photos, I think.
All right.
That should be fine.
And so with that, we don't need to address that motion today?
I don't believe so.
No.
It can be difficult if you have
I did
photos.
consult with the development, my expert, and I told him that it's my feeling and understanding that we would not be doing the doe bed today, so I'm good on that.
Okay, all right. So we won't address that. So just, why don't we talk a little bit about impanelment and the procedure that
If you'd like to see Lindsay Clancy, come to your screen. That is Lindsay Clancy sitting next to Kevin Reddington profile.
I would consider doing is implementing a questionnaire. And I drew up a draft of one. I'll give it, we can kind of do a final talk through on Monday when we do that. But this is just so you can take a look at it. It's just 8 or 9 questions. So my thought would be have the jury come up here as a whole, give them an introduction to the case, give the Commonwealth. Do we have a statement of the case?
Yes.
I submitted the final pretrial memo. I believe defense counsel submitted a paragraph that he would like read that the Commonwealth's objecting to.
All right. Well, why don't so we'll circle back on that, and then go through the general questions with the jury, then send them back downstairs to fill out this questionnaire. My other thought is that there is an extensive witness list. And it may make more sense to have the jury be handed a copy of that list, and bring that down with them when they're answering the questionnaire, because last I counted, it was over 200 names. And I think it would be difficult for anybody to sit there and try to remember who it is. Do I know that person or not? So my thought would be to give them the questionnaire, give them the witness list, send them downstairs to fill that out. That then gives us an opportunity to take.
Liza, you keep putting spoilers in the chat and I keep deleting them. Could you just not? Maybe we're going to get to it. That would be nice. Thank you.
Break, line up for the individual part of the voir dire, and then bring them up and bring them in one at a time into the courtroom over here at sidebar, and just proceed that way.
I think that's a good idea, Your Honor. I would just ask that those witness lists be collected from the jurors as they leave.
That's a good idea. Yeah, I have Mr. Reddington?
Yeah, that's fine.
All right. So that's the way we'll do that. Let me see. I have here's a draft of those questions on and we can go over these on Monday, but this is the proposed. Don, could you email those to counsel?
Your Honor, the witness list, would that be a combined list with both?
Right, and they won't be listed as defense or Commonwealth witnesses.
Thank you.
So this is just a rough draft of the questions, and then bring them up. My thought would be to impanel 18 on this case, because it's going to be a lengthy trial. And then so everybody's going to get, well, I know there's a motion for additional challenges. So why don't I hear you on that at this point? Mr. Reddington?
Are we going to talk about the questionnaire eventually, or?
Yeah, I'll give you two, I just.
Okay. Thank you. Your Honor, I have filed a request for additional challenges. I understand that would be entitled to 18, is that correct?
Correct.
Because I was told you might contemplate 18 jurors.
Yeah, we're going to seat 18.
So I'm asking, and I don't know if the government agrees, that we would have additional jurors. Obviously, that would be committed to your sound discretion, but it's the type of case, not only publicity-wise that we usually deal with, but just the sheer emotional impact that this case is going to have on jurors. And I have always felt that jurors really, take to heart their obligations under a jury trial. And I have literally had occasions where I've run into jurors from older cases, emotionally charged cases, in public places, and they would shake my hand and they cry. And that to be like 5 or 10 years later. And the impact of this case, which in my decades of trying cases is probably the most emotionally disturbing and challenging, I think is going to have a significant impact on jurors, more so than the usual that we deal with. So recognizing that 18 challenges might sound like a lot, I just feel that perhaps an additional number of jurors subject to your discretion would be appropriate, especially with the length of time that they're talking about, along with the emotional factors.
Come on.
I would join in the request for the additional peremptory challenges. And I just have a question in terms of if the court is going to impanel 18 about the seating of the 2 additional, because we want to make sure they have adequate viewing of the monitor and the witness box. But other than that, I have no objection.
I don't remember the last time we saw a case with 18 impaneled jurors. Do you? It's going to be really hard to watch. This case is going to be really hard for jurors, really hard. I mean, a lot of the stuff is not going to be shown to the public. The video footage of them coming on the scene. It's going to be horrific. Pictures of the children when they were found, horrific.
All right, I want to consider this motion. With both parties requesting it, puts in a little different path that you usually have on this. So, but I do understand the uniqueness of this case, the allegations. So I'm going to take that under advisement. We'll let the parties know in the next day or two. So that'll be under advisement. And in regards to the seating of the jury, my thought would be, as I've done before, is to have not to have those 2 side by side, but one in front of the other. And I think we haven't had that problem before in regards to being able to see either the witness, because it kind of lines up, and then the screen, which I imagine is going to be used here. Might have to turn it a little bit, but the cases I've done before with the 18, all the jurors were able to see. And then what we'll do is I'll just ask them as we're going through this, because everybody can see this. If you can't see it, let us know. If we have to adjust the screen or adjust the seating at that point, we'll do that. But I haven't had that problem, but I don't have them side by side like that. So, all right. Any other questions in regards to the impanelment, Commonwealth?
No, Your Honor.
Mr. Reddington?
I don't think so.
I think we've all done cases with each other, so I would expect they'll be kind of handled the way we've done it before. So, that would be the impanelment. As I said with the schedule, as I indicated over here, I'm going to tell the jurors what the schedule is going to be, but let them know that it's a fluid situation in regards to how long the trial is going to be, how long the schedule's, on a day by day. So I'm not going to be very precise, I don't think. We'll talk a little bit more maybe on Monday in regards to how I address that with the voir dire. Let me see. The other issue that I had just in regards to, and I know Mr. Reddington indicated that you don't believe there's going to be a request for the defendant to be absent from any of there. And so what I would, just so the parties would know, if that comes up under Rule 45, what we'd do is we'd just do a colloquy, maybe do a signed waiver, and we could deal with it that way. So it wouldn't take up a lot of time. I think it's just better for everybody to know that's the procedure that I would follow, kind of after looking at the case law on that. In regards to the view, I know that I had allowed the Commonwealth's motion for review. There was a proposed order with the Commonwealth's motion. I don't think I got a proposed order from the homeowner. And I think he was invited to propose one, but I haven't seen anything. So Commonwealth, what's your position in regards to, it was your order, but what are your thoughts in regards to that?
Well, I was approaching it as most of these types of cases that I do. We usually let the homeowner know when we'll be there. They make sure they're out of the home and it's unlocked. We go in. A case like this where we have 18 jurors, maybe send them in groups of 4 or something along those lines to see whatever myself and defense counsel want them to take note of, and then leave the premises with an instruction to the jurors they're not to open.
Is this the case where a DA or somebody who works for the DA's office bought this house? Or am I conflating my cases now? Because they want to take the jury to a view of the house. I don't know why. There's no question that she killed her kids. Okay. There's no question about that. She's admitted it. They're going to try that part of the case anyway. I don't know why they need to go to the house, but it's what they want.
Any closets or anything like that, or touch any personal items. And I think that's pretty much what's encompassed in the order, if I recall.
Yeah.
Right. It was
Mr.
somebody from the
Reddington?
DA's office who didn't even want them there. I'm like, first of all, you got a good deal on a murder house, right? Because nobody wants to buy a murder house. You always get a good deal on a murder house. And he's like, I don't want you coming in my house. And she's like, yeah, they should just leave the door open so we can all go in, with them not there. And we'll just, we won't open any closet doors or anything. I'd be like, yeah, no, I don't want anybody traipsing through my house. No.
I have no position on that, Your Honor. Your Honor knows that I indicated I don't think it's necessary to have the view plus videos plus photographs, but I understand you've already made your decision on that. So it's a house that is now occupied by a man and his partner. It does not look at all like it did before when Lindsay and her family was living there. So I defer to your discretion on any specifics on the view.
All right. So my intention would be to, as I said, allow the motion for the view, issue that order in line with the proposed order that was given by the Commonwealth, and then as we go forward, we can give the homeowner a notice on that. We'll have police and security there to address any of those concerns. In the order regards to the media, we'll also deal with the no photographing of the jury during the view.
Could I just make an observation, Your Honor?
Sure.
It's a situation where obviously we're dealing with people that are civilians or professionals. This is not a situation where we're looking at a drive-by murder in the middle of an inner city where there's danger to jurors and stuff. Can I ask that the court at least limit the police presence? I mean, I have had it with police officers on motorcycles buzzing back and forth next to the jury bus, and police officers stopping traffic and blue lights behind you, blue lights in front of you. There's no need for that type of a police presence in this case. We're going to take a bus to a house in a residential area in Duxbury, and that's it. I understand that there may be a need to, close down a road or something, but I would ask that we don't have such an overwhelming police presence for obvious reasons.
We could go to sidebar. We do have a plan in place, but for security purposes.
Sure, yeah. You see sidebar?
Reddington doesn't want the circus. He's like, we don't need the blue lights. We didn't need all the blue lights. All right, let's fast forward through the sidebar.
All right, one of the I know motions that was filed and argued had to do with photographs. I know, and I allowed the Commonwealth to be able to introduce some photographs. Just so, again, there's no surprises. If the Commonwealth can provide me a copy of the photographs that they intend to introduce, so I can look at them and make sure, no surprise, but would be in line with the ruling that we talked about.
Are you referring to the autopsy photos, Your Honor?
Whatever photos, or the crime scene photos, perhaps.
We could provide you with either the disc with all the photos, or it's the issue. The reason I'm hesitating is at the moment, as we're prepping, we're deciding what photos to use, but that could change mid-trial. So I could give the disc with all of the photos for you to review and be prepared in case there's an argument about one of them.
I don't think there's going to be. We've already kind of had the argument in regards to photographs, and I also allowed that some photographs will be admitted with limiting instructions. But I just kind of want to make sure that I understand really what the jury is going to look at, so I can make that final determination. So kind of however you want to do it. If you want to give me all the photographs, that's fine, or just some representative ones. I'm not going to hold you to if there's one that's a little different angle from some other one, but just so I have some idea kind of what we're going to have to deal with.
And I can bring in copies of the autopsy photos as well.
Okay, that's fine.
Autopsy.
All right, thank you.
Do we need autopsy photos? Come on. I don't know.
The other thing we had talked about last time was that the 3D model was, I'm not sure if that was done or if that's an issue now, or.
It's almost complete. I'm expecting to, Sean Marucci from our office has been working on that, and as soon as it's done, provide a copy to defense counsel in the court to look at. But it's going to be a digital monitor that's on the screen.
So it's a digital representation of the house?
Yes, a digital model of the home. It'll have an exterior view, and then it'll have each floor of the home. And it's just a digital model, nothing physical.
All right. So if you could just make sure Mr. Reddington sees that, and then we can deal with that as we come closer.
I'm sure they will. I have no problem with the AutoCAD stuff. I may have one myself.
Okay. All right. So we won't worry about that. The blood spatter motion, we're going to take that up later. What other issues do we have?
That's true. I think that's true. I think the reason they want the home visit is because they're trying to say that the window that she jumped out of wasn't high enough, so she really didn't mean to kill herself, and she knew it.
One in regards to some additional witnesses, but besides that, any other issues we need to take up?
The Commonwealth sent defense counsel several proposed stipulations. It would be helpful to resolve those.
I haven't had a chance to look at them yet, but I'm sure that I'm more than likely going to agree with all their stipulations, because if it's to avoid having people, in a ministerial sense, like somebody looked through a scanning microscope and they handed a slide to somebody else that put it in an envelope that somebody else looked at. I have no problem with that. I'm not, as you well know, we've indicated that the mechanics, if you will, of the homicides and the actual event itself, we're not contesting. This is why you've already heard me complain about the autopsy photographs and all the gruesome stuff we're going to have to live through. But as it relates to the stipulations, I'm more than willing to stipulate to avoid having all these witnesses.
And just so the court's aware, they are witnesses, as defense has described, mostly laboratory witnesses. It would save calling 31 people.
Yeah.
So.
All right, and that's kind of what I figured was coming. So that's I'll anticipate that there's going to be a fair amount of stipulations that'll be done. I'm not going to hold anybody to it at this point till we get the specific language in it.
My only concern is that in light of Commonwealth versus Gordon, I think there needs to be a colloquy with the defendant about the stipulation. And I haven't done one myself, so I don't have a model for the court. I'm not sure if other judges have done it at this point. But that's something, I think it would be something along the lines of other similar waivers of a constitutional right, but.
When someone stipulates to an element.
Right.
Yeah, so well, I'll either borrow one or draw one up. So I think that's a good idea.
Mastad, tell me if I'm thinking of the wrong case. Mastad says she's not pleading guilty. That's why there's a trial. Didn't they offer to concede that she committed the murders if they could just go to trial on the penalty phase? And the Commonwealth said no. Am I thinking of the wrong case? Because I thought that is something that Kevin Reddington did offer, and then the Commonwealth shut them down. And that's why we're going to have a trial on the whole entire thing, right?
All right. I know that there was still a couple of remaining discovery motions that were kind of floating around. Do we need to address any of those, Mr. Reddington?
Okay, I was right. Thank you.
Are you referring to Dundat's motion for relevant discovery?
Yes.
Okay. For the record, I would note, Your Honor, paragraph 1, I'm looking for automatic mandatory discovery. I believe the government has been very effective in providing me with discovery. I mean, when there's a witness that's interviewed, they send me a copy of the interview. If there are notes, they send me copies of the notes, so I don't have any problem with that. I don't believe that there are any unusual issues that have been flagged on this motion, and I would ask if the court would entertain allowing paragraph 3, which is potentially exculpatory evidence, only because I know the case law, not that I doubt that they would provide me with exculpatory evidence, but I believe I have to have a motion allowed for the record to have it in play as far as the government's obligation that they recognize, and I respect the fact that they do and expect that they would, but nevertheless, I would ask that you allow motion for exculpatory evidence, as well as motion for statements of the defendant. And again, I don't anticipate that there are extensive statements of Ms. Clancy to law enforcement. I don't believe there are literally any. And I'm well aware I have the discs of the government's doctors interviewing her, so I've already got that, but I would ask that you allow that motion as well.
Commonwealth?
So if I'm understanding correctly, from this motion, defense is just asking for the allowance of paragraph 3, and then any statements of the defendant, is that correct?
That's correct. Yep.
So I have no objection to statements of the defendant. We've provided those, and if any come to light, we will of course turn those over, but I don't expect any. In terms of paragraph 3, my concern with paragraph 3 is the last paragraph, the last couple of sentences where it says the new Rule 14 also requires the Commonwealth to inquire of each witness, officer, and agent and agency as to whether they know of or possess any exculpatory evidence. And then that last sentence, the defendant requests this court order the Commonwealth to produce each and every inquiry and each and every response.
I would narrow that, if I could interrupt, I apologize. I would narrow that to, in the event that there are statements that disclose exculpatory evidence, the government would then advise the defense. They don't have to notify me of every single person they've talked to.
Well, so I made a note of that. I was wondering the definition. I'm going to make a suggestion. Maybe if the three of you can kind of come to an agreement as to that language.
Yes.
And then I'd allow that as to make the endorsement that reflects the actual agreement instead of just kind of a blanket one that the parties may later disagree with what was meant. So I'll allow that pending the proposed language. All right.
So that would just be paragraph 3.
Paragraph 3, and also regarding the statements of the defendant.
Which I don't think is its own paragraph in here, is that correct?
I'm sorry? What?
Statements of the defendant, is that a specific paragraph in your motion? Or
It
just
would be,
general?
yeah, just statements of the defendant in general, yes.
In general, okay.
Okay. All right.
And no further action on the rest?
Right.
As of now?
All right.
Your Honor, there is a discovery motion filed as well where it's a request for a 17B2.
Yeah.
Looking for state police troopers, local police detail to sit at defendant's hospital room. Government has provided me with today a large number of duty assignments and records and documents. I believe they're going to provide me with the state police, but I would say that motion can be tabled.
So I'll take no action on that. I think that's pleading number 113, rule for motion discovery under 17B2.
Correct.
All right, so there'll be no action taken on that.
Okay.
All right. And then I think the only other kind of issue that we need to take up is the defendant's motion that was filed.
No, there are a couple more.
No, there are. Sorry.
Yeah, very briefly, Rena, as counsel had already indicated, on the document titled Joint Pretrial Memorandum.
Oh, yeah, okay.
The government sent an agreed statement of facts to be read to the jury, basically alleging on January 24th, 23, the defendant strangled her 3 children, naming them and their ages, with exercise bands in the basement of their home, thereby murdering them with deliberate premeditation and extreme atrocity and cruelty. And that's the extent of what would be referred to as the agreed statement of facts by the government. I then submitted a request that Your Honor would consider adding a paragraph that Lindsay Clancy denies the allegations that she is guilty of, quote, murdering them with deliberate premeditation and with extreme atrocity and cruelty, end quote, and notes that she has accepted responsibility for the acts resulting in the death of her children, however, was lacking criminal responsibility at the time of the acts as a result of postpartum depression, psychosis, and involuntary intoxication. As a result of ingestion of numerous prescribed medications, Lindsay Clancy is thereby alleging she is not guilty due to the lack of criminal responsibility and will present what is referred to as the insanity defense, which I know was one of the questions that you had put in the questionnaire.
Come on.
So, Your Honor,
Ms. Wright, do I have a copy? Is that submitted?
I mean, we send them all to the
I
clerk.
provided a copy of the joint pretrial
I
memo to the
have
clerk.
the joint pretrial, but I'm just,
The statement of facts is at the beginning, the proposed statement of facts for the Commonwealth.
I was looking for Mr. Reddington's version.
Because I know I sent them to them. I know we sent them to the clerk.
All right. Yeah, go ahead, Ms. Brigg, I'm sorry.
So the Commonwealth would object to the paragraph as a whole. We would not object to the statement, Lindsay Clancy denies the allegations, and that she is alleging she's not guilty due to a lack of criminal responsibility.
Master, I'm just complimenting your use of the word foment. Just our new word of the week. Foment means instigate. Somebody's trying to say that a nurse said something about Lindsay Clancy's behavior in the mental hospital where she has been confined since her arrest. And that's bizarre. That a nurse would tell you something about a patient in her hospital. I find that hard to believe.
But the rest would have to come in either through her testifying or other witnesses testifying, saying that she denies the allegations that she's guilty of murdering them with deliberate premeditation and extreme atrocity and cruelty kind of flies in the face of the statements earlier that what happened is not in dispute. So that is the reason for having the evidence about what happened to Cora, Dawson, and Callan, and including the autopsy photos, because that all goes to extreme atrocity and cruelty and deliberate premeditation. And then the rest where it notes that she's accepted responsibility, again, that would be putting evidence before the jury or statements before the jury that may or may not ever be in evidence. So I think the standard, she denies the allegations, and then including what the defense is, which I usually object to, but I'm not in this case because it's public knowledge. So those two statements I think would be sufficient, and I don't think the rest would be appropriate.
What I've done in past cases like this, I think the one we did a couple of years ago, was basically in the statement of the case after with the Commonwealth's allegations to say something about the question before you will be whether or not Ms. Clancy was criminally responsible if she lacked criminal responsibility. The prosecution has the burden of proof. The prosecution must prove beyond a reasonable doubt that she was criminally responsible at the time that she killed her 3 children. Any objection to that?
I do object to giving an instruction such as that, in that the case law states that we're not required to prove that she had criminal responsibility until the defense raises it. So at that point, at the beginning of the case, it hasn't been raised. I'm not objecting to it, that's her defense, that she lacked criminal responsibility. But I object to an instruction at the beginning when that evidence hasn't come in. I expect it to come in, but things change during trial. You never know. It's the same as with self-defense instructions. I object to those at the beginning of the case because it's dependent on evidence that comes in during the trial.
But then what's the basis then for asking the jury
Hold on. This is the
the
same
appealment
person.
questions
How
about
did
their
How did
position?
you slip through the cracks, Eliza Vino? This is the same person who the other day said Melanie doesn't like it when Melanie doesn't like to cover bad news when it applies to Karen. Oh, how did you even get through here? How did you get through? Oh, sweetheart. Block Island is so lovely this time of year. You're just coming in here to rabble rouse and rage bait. It's not going to work today, honey. Peace out. Enjoy. I agree with you, Mass Dad. Oops.
Regarding the defense of criminal responsibility.
Because like self-defense, we expect that will be an issue. So we want to know if it's going to affect our ability to be fair and impartial. But I don't think the instruction comes until it actually becomes an issue. And I understand it's the court's discretion on that issue.
Yeah, I'll take a look at them, but just so everybody, I'm probably going to give something similar to what I just kind of read out, just to kind of tell them this is the issue. You know, this is the defendant's position that she was not criminally responsible. This is the Commonwealth's position, is that she committed a crime. And so it'll be something along that line. And I'll show everybody before we read it to the jury, so everybody can kind of have some additional feedback, but it'll be something similar to that, I bet. All right. What else? Any other issues before we get to the?
I did file a request for the court to consider, I don't know if you have it, the motion to sequestration of the jury. You didn't have that?
No.
Okay.
Have you seen this, Commonwealth?
I have, Your Honor.
Like I say, I know that when we file them, we send them to the DA, we send them to the court, so.
No, I have to follow my sword. It was sent to me. I had seen this one.
So the motion's allowed?
No, but I'd like to.
A judge falling on his sword. Wow. If you guys could also just refrain kindly. I know this case has a lot of you and with some very strong emotions. Could you please just refrain from putting curse words in the chat? Because I don't want to have my channel stricken because some people can't control their language. Thank you so much.
Just so I don't blame somebody else. It was sitting on my desk. All right. Well, Ms. Rachel, I hear you on this.
Thank you. Your Honor, I basically can be very brief. This is, as I indicated, a very unusual case, emotionally, factually. Government's estimating 6 to 8 weeks for a trial, maybe less.
6 to 8 weeks for the trial. 6 to 8 weeks. I don't even know how long it's going to take them to get a jury on this case. There's a lot of people who are going to come up and say, like, listen, I can't handle this. I can't handle this. She's 100% guilty. I don't care. I don't want to hear any excuses. I'm out. That's what I think. It's supposed to start on Monday with jury selection the 20th.
Stipulation. Nevertheless, it would be a huge imposition on jurors. There has been extensive pretrial publicity, as you know, from the motion for a change of venue, which Your Honor heard and denied, which would be renewed at the time of the impanelment, depending on the way the jurors react to the questions in the sidebar individual voir dire. So my concern is that with all of those issues, and I understand that it's unusual nowadays, we don't really do sequestration of jurors. I think this is a very unusual case that may warrant that. And even if it's a
Massad, with thoughts, they're not going to sequester a jury for 6 to 8 weeks. You mean put them in a hotel with no phones? I don't think that's going to happen. The county's not going to foot the bill for that. I don't think so.
possibility during the course of the trial, I think that the court should at least flag that issue for the potential jurors, for them to factor that into their own determination of their availability. So that's why I filed the motion.
Come on.
Your Honor, Commonwealth objects to the motion. I think that the court will instruct, well, I know that the court will instruct the jurors not to go on social media, not to read about the case, not to pay attention to any of that. In addition, the court typically asks the questions every morning. If they've been able to follow those instructions, they're presumed to follow those instructions. So I don't think sequestration is necessary, and I don't think it would be necessary to ask them about something that may never happen in the case at impanelment.
I'm going to deny this. I will.
Denied.
Said I'm going to ask the jury if they've heard of anything before, if it's affected.
Kevin Reddington asks for everything, knowing that he's only going to get a percentage of it. He does. He's asked to change venue. He asks for everything, and he should. He's a very zealous advocate for his client.
Their ability to be fair and impartial. I'm going to ask them every day whether or not they've seen anything, and also go instruct them not to view any articles or social media in regards to this during the course of that. And I'll follow up every day to make sure they follow those instructions. So I'm going to deny this motion.
Do I have to note an objection every time you deny a motion?
No, I think my denying it is to save that.
And I think there's one more motion.
All right. Okay, yeah. All right, what's the last motion?
Last motion, Your Honor, before we get into the jury questionnaire, I think would be caption the defendant's motion for jury instruction. You have that?
I don't have that. Yeah, keep it down.
Thank you, Tammy. I'm sorry about that. Thank you for your 10.
Oh, you have to video.
Yeah, you guys are saying that Mark Diller was at
When
Karen
you
Reed's
give
hearing
me,
today. I'm not surprised about that at all, because Mark Diller was at the entire trial. Mark Diller sat through at least the entire second trial. So I'm not surprised at all that he was there. Thanks, Karen.
Instructions to the jury on the law after we've picked the jury, and I believe you do it before openings. In light of the fact that it's obvious that lack of criminal responsibility is the defense, is the central bedrock of the defense in the case, I would ask that the court would, in addition to instructing the jury, as you do in the generic sense, about proof beyond a reasonable doubt, that the court would also instruct the jury that as it relates to the burden of proof, in the unusual situation where you're dealing with lack of criminal responsibility, that it is not the defendant's burden to prove that she was lacking criminal responsibility, but in fact, upon presentation of evidence, it's the government's burden to prove beyond a reasonable doubt that she was not acting as a result of a mental disease or defect.
See that? Burden shifting. So once the defense brings up lack of criminal responsibility due to, in this case, what they're going to say is over medication and or postpartum psychosis, the burden shifts to the Commonwealth to prove that she wasn't.
So I'm just asking that you would add that to the generic instructions.
Your Honor, similarly to the argument that the Commonwealth was objecting to the criminal responsibility being mentioned in the statement of facts, we would also object to the preliminary instruction, full instruction about criminal responsibility, because as my sister said, it is, the defendant still has to raise it, and they have to raise it not.
It's my brother. He's my brother, not my sister. Unless she's talking about her. I thought, oh yeah, her co-counsel, I guess she's talking about. Okay.
Just by saying it in an opening statement, they have to raise it by expert testimony, lay witness testimony, or the actual facts of the case. And so that isn't done until the case is underway, and preliminary instruction it comes well before that. So that is relying on Commonwealth versus Santiago, 485 Mass 416, a 2020 case that reiterates the instruction isn't necessarily need to be given in a preliminary, or in that case, it was actually for a jury instruction at the conclusion of the case if the evidence wasn't raised. But I would suggest that the idea is even stronger, that if we haven't even presented the jury with anything, then they shouldn't be preliminarily instructed on it. If Your Honor was inclined to give it, because it is a discretionary thing, I would ask that you stick to the language of the model and not how counsel phrased it, because as you're familiar, the actual instruction when it comes to what the Commonwealth must prove with a criminal responsibility issue is not just whether we can say that they don't have a mental disease or defect, because the evidence may show that, but that is not the requirement for the jury. If there is a mental disease or defect, then the Commonwealth has to prove the other two prongs of the criminal responsibility statute. So the way it's phrased in the motion, I'd ask you not adopt that language and that you'd stick to the model if you are inclined to offer it, but we would object to the giving of it.
What if I instructed the jury in a sense, almost like hypothetically, that it's anticipated that the defense of criminal responsibility is going to be raised? If that's raised, this is what the law is.
Well, I would suggest that we don't want to be caught in a burden shifting situation on a preliminary instruction. So maybe that language is a little bit too close. I think it's either Your Honor gives it as it is in the model in the preliminary as a preliminary instruction, or it's not to be given and just to be addressed at the conclusion of the case.
I generally give it. I understand the Commonwealth's position, but I generally think it's a good, well, I'll just leave it at that. I generally give that. So I'll take a look at, but I generally give the model language that's suggested. All right.
I think that concludes the motions.
All right. And then there's one last motion that was filed yesterday. The Commonwealth had an opportunity to review that.
Your Honor, I briefly looked it over. I would suggest that we shouldn't even broach this motion in that it violates Rule 14 discovery and that these individuals have been identified by initials only with no other information, no statements of the witnesses, no indication of what these witnesses have to offer or the background. And it's 1 week prior to trial. So I'd ask that it just be denied on its face.
Well, I understand that, but it's been raised. So I'm going to hear from the Commonwealth, and I'll hear from the defendant first, and then from the Commonwealth. I'm sorry, and then I may have to take it under advisement myself, and it may be the argument that there's just not enough here for me to make a decision is there. But I think I want to give the defendant the opportunity to argue this. So, Mr. Reddington, this is the motion to eliminate to permit testimony from witnesses who have themselves been, according to the motion, victimized by the medical system regarding the issues of postpartum depression and postpartum psychosis.
Yes, Your Honor. Thank you.
Well, that's interesting. Listen to this. That's a novel idea. Reddington is an excellent attorney. Everyone who knows him says he's a great guy. He did represent Jennifer McCabe at one point during the Karen Reed pretrial hearings for her phone records. Regardless, he's a great attorney, and now he wants to bring some witnesses up who have been victimized by the medical system. This is interesting. I don't think he's going to allow it, but I want to hear what he's got to say about it.
Your Honor, as I say in the affidavit, and as you can well imagine, I have been contacted by many people who have, in a very moving, emotional fashion, advised me of these horrific issues that they've been dealing with postpartum depression, postpartum psychosis, hearing the auditory commands, having intrusive thoughts to hurt or kill their partner or their children, infanticide, as a result of postpartum psychosis, medication issues, contributing to the postpartum depression, postpartum psychosis. And it's so easy for us as a society to say in a troubling case like this, oh my God, she's guilty, throw away the key, put her in jail and just be done with it, because it makes everybody feel better. It's a feel-good reaction that, okay, somebody has been punished because of doing a very bad thing. But as we know, when you're dealing with the issues of lack of criminal responsibility, I don't like the term insanity, but nevertheless, when you're dealing with somebody who is suffering from a medical a defect or a disease, and they have actually experienced something that is so outside the ken, if you will, of jurors, of normal people, for us to believe that somebody's hearing voices. The initial reaction from any one of us, I think, in this courtroom would be, come on, you're not hearing voices. What are you talking about? You're making this up. You're trying to avoid responsibility. But it is true, and it happens, and it is an affliction that people have put up with. And if they are permitted to testify as their experience themselves as to postpartum depression, psychosis, the concerns and the fear that a woman has, and I say as a woman has, because guys don't know about this. You know, we're so quick to go out and we're mighty and strong. We have many beers, and we're real quick to say, throw away the key on it. But a woman who has suffered and has put up with this affliction should be able to testify and say, probably in an emotionally charged fashion, very credibly, I too have heard these command voices. I too acted on the command voices. I too have had insomnia. I too have had hedonism where I don't even care if I live or die. I have no emotion. I can't feel. I can't laugh. I can't love. I can't hate. And I think that that is important. Now, before I disclose the identity of these people, it seems to me that what I have to do is present the general legal issue to you as a preliminary gatekeeper almost, where you would say, hypothetically, I think upon sufficiency of proof, it is admissible. And I am inclined, you the judge, to allow that evidence before a jury, at which point I would then, of course, disclose the identity of the people with their knowledge and consent, their medical backgrounds, and the government could then send their cops out to interrogate them or intimidate them or talk to them or do whatever they want to do. But if they get on that witness stand, they have credible evidence to give. So it's a two-part. I can't really give their names and addresses without knowing. You may say, as a matter of law, it's not admissible. Somebody's individual experience with a narcotic, with a drug, with a disease or a defect is not admissible in a sense of the specifics of a trial. And if that's the case, then it shuts down the issue and that's the end of it. But I had to raise the issue preliminarily.
Thank you, Your Honor. I'll incorporate what I said before about the Rule 14 and the lack of notice in the 1 week prior to trial, but also defense counsel cites no rule of evidence that would allow for the admission of layperson testimony about these issues. He cites
I think it's more of a matter for the experts to testify about, the medical expert. I think Dr. Zeisel is on this case, I think, right? And we saw Dr. Zeisel testifying, Lucy Medina, and other cases. He's amazing. I think, unless I'm conflating this case with the 1,000 others. We have already covered 4 cases today. I think it's more prejudicial than probative. It's a very novel argument. I don't recall ever having this kind of evidence admitted at a trial before. But let's see. This is Lindsay Clancy.
To the battered woman statute, but in that statute itself, it refers to expert testimony, not laypersons saying, I had this experience, so the defendant must have as well. And then I think what we come to is it becomes more prejudicial than probative in that, you allow 16 people to come in and testify to that, then the Commonwealth gets to rebut that with their own witnesses. Women who suffered from postpartum depression and psychosis, who did not kill their children, who locked themselves in a room to keep themselves from harming their children, who got in a car and drove away so they didn't harm their children. And so then it becomes a trial within a trial. And it's more prejudicial than probative. There's no rule allowing the admission. And it would delay the trial, in all honesty, because then we would be filing a motion for discovery on these witnesses, their medical records, having them interviewed by police, which would take time. So I would object to this motion.
I'd like to know who these people are that were locking themselves in rooms and getting in their cars to avoid killing or hurting their children.
Just go on Facebook, they're all over.
But isn't that the whole problem?
Just go on Facebook, they're all over. Oh, I think we're getting a little taste of how this ADA is going to be trying this case, eh? Plenty of people get postpartum and they don't kill their children. Makes you different. Just because you didn't kill yourself doesn't mean you shouldn't get locked away in a cell for the rest of your life without any mental health help. Just go look on Facebook. They're all over. Yeah, they're also over in law and crimes chat. Oh, man.
I think what the Commonwealth is saying, that this isn't just a trial within a trial. It would be 16 trials within this trial. I understand the argument, especially the kind of comparison to the battered women syndrome. But as those cases develop, I'm sure Mr. Reddington may remember, as those cases that became more and more admissible, it really hinged a lot upon the testimony of experts. And in this case, I anticipate there's going to be experts that are going to talk about the reality of this postpartum depression and postpartum psychosis. So that's coming out. And these are testimony that will come from the experts, I think, on both sides. It doesn't seem like there's a question of whether or not postpartum depression or psychosis is real. I mean, all the experts seem to agree that it's real. So because of the ability to get the probative part of what those women would bring to the court, the experts can give that.
Yeah.
So I'm going to deny the motion at this time. All right. Anything else we need to address, Commonwealth?
I just think on the questionnaire, I was looking over the questions. I don't have any objections. I only request an addition. On number 2, it asks about a family member or close friend being diagnosed with postpartum depression, or generalized anxiety disorder. It also asks to include bipolar disorder, as most of the experts in this case have diagnosed the defendant with bipolar disorder. So I think it'd be important to have that information.
Anything else in regards?
And also, Your Honor, there's no question on here regarding medications, whether people have any experience with psychiatric medications and whether that would affect their ability to be fair and impartial, either experience or views about. Is that the case?
All right. Mr. Reddington?
First of all, if I could just harken back to the orders that you've given on the motions in limine, and I don't even seem paranoid, but you, I'm sure, understand. The appellate courts in Massachusetts have repeatedly stated that on a motion in limine, if the defense counsel does not object, you're waiving it. So I just want to make sure, number one, for the appeals court, if necessary, or the SJC, I object. And is it my understanding that any further objections, I don't have to keep objecting because I respect your ruling that I don't have to?
Come on. I have no problems with that. I think especially it's clear that the issues were raised on the motions to eliminate. I've ruled on them. And I think there doesn't need to be a recurring objection on those.
I would agree, for the record, Your Honor, that if whichever party was affected by the denial, the objection is there.
Okay. All right.
All right, addressing the questionnaire, Your Honor, if I may, it's an interesting issue that we're dealing with. The questions that have been requested, have you, a family member or close friend, ever been diagnosed with postpartum depression, or generalized anxiety disorder? The next question is, skipping over the NGA, number 4, have you, a family member or close friend, ever been diagnosed and or treated for mental illness or condition? And then going down to number 6, have you, a family member or close friend, had an experience with a psychiatrist, psychologist, or mental health facility that would make it difficult for you to be fair and impartial in this case? And finally, number 9, do you believe that a person's mental illness should not be considered when determining their guilt or innocence? So, going backwards, number 9, this is very similar to when we ask jurors or we tell jurors, do you understand that a defendant does not have to testify in this trial? Do you understand a defendant does not have the burden of presenting evidence on his or her own behalf? And many times at sidebar, jurors will say, well, I think they should tell their side of the story. And then the judges will say, well, if you are instructed by me that that is not to be considered, can you then abide by my instruction and be fair and impartial, and they always invariably say, well, yeah, I could, I guess, and then they will be accepted. I'm concerned about raising all of these so personal issues. There is a stigma in this country of mental disease or illness. There is, whether we acknowledge it or not, and it's embarrassing.
He's not wrong.
To many people, and I'm just concerned that jurors would, let's say they answer yes to question 2, that you or a family member has been diagnosed with PPD or depression or generalized anxiety disorder, and they say yes, then that's going to open up the inquiry into when, where, how, who, what medication,
right,
and will then invariably lead to kind of an inverse challenge by repeated challenges by the government, I think, to pretty much any citizen who comes in here. It's almost like a reverse Batson challenge. Any citizen that comes in here and has had mental treatment or has had what they perceive to be a mental disease, and they have been on medication, they're going to say hypothetically, yes, I have. And I saw Dr. So-and-so, and I think that the shrinks are useless, and I think they're terrible, and I think they're horrible, and they ruined my life. They're gone. They're going to challenge that person. If a person says, yes, I had medical treatment by a psychiatrist and I was on medication, that begs the question, how did that work out for you? Was there any issue with the medication? Anyone that has any issue whatsoever with mental disease, defect, or medications is going to be tossed because of alleged cause. They're going to say it's for cause because they have a preconceived notion. And that's going to wipe out a significant number of citizens that are being brought here to this court to sit on a jury, recognizing the fact that the issue of mental disease, defect, treatment, lack of criminal responsibility is central to this case. I certainly have no problem, and I have confidence, as we always say, that the court will give a very forceful instruction to the jurors that regardless of any preconceived notions, that they come into this court with a clean slate and they have to listen to the testimony and listen to the evidence. We do it all the time, usually to the detriment of the defense, but we do it and we say, okay, can you understand what I'm telling you, that you don't have to listen to this, or that you don't have to feel the defendant has to present their evidence, and we accept them as jurors. So I don't think it's fair to exclude a potentially significant number of people that would be good citizens, good jurors, just because they have had mental disease or treatment, psychiatrists, psychologists, MDMA, or whatever they call it, or any of those treatments, or medical issues with medication.
Psychedelic journeys now we're getting into, Reddington?
I just think that we're flirting with disaster on that type of question.
So what would you want me to just ask number 3?
Number 3, looking at number 3, I think is fine. The defense in this case is that Ms. Clancy is not guilty due to not being criminal or lack of criminal responsibility. At the time she killed the 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? And then they come up on the individual voir dire and they say to you, in our presence, yes, I don't like psychiatrists, or I don't like psychiatric medications, or my brother did something or other. Yeah, I think question 3 captures it. Instead of going through all of those questions, number 2, 4, 6, 9, I think number 3, I have no problem with.
Kamala?
Your Honor, I think the questions should remain as they are. Defense counsel's only objection to them seems to be his belief in knowing how we're going to make decisions and how we're going to address issues or answers that come up at sidebar. And he is wrong about our approach, and he is wrong about the way we handle things. I can speak for myself, and I can say that.
Sweetie, you're the one who brought up Facebook 5 minutes ago, okay? You're getting your legal theories on Facebook, and you're already looking at the comments on Facebook to find out what people think about this case. You can't start asking potential jurors about their psychiatric history because many of them may not tell you the truth and it's going to be a problem. It's a little invasive.
If a person comes up and says that they have had mental health treatment, mental health medication, I have no issue with that, as long as they can be fair and impartial to both sides. And I mean both sides, not just me, to the defense as well. Now, his example that he gave, that someone says, I had an awful experience with a doctor, it ruined my life, and I can't be fair and impartial. I should think that neither side would want to take that person, because we want a fair and impartial trial for both sides. So I think the questions are fair. I think the questions get to the heart of the issues that will be in this case. And I think a lot of them get to the issues that case law in this area addresses we should ask about.
This is a prosecution who didn't even want Lindsay Clancy at the trial because they thought they didn't want her wheeled in on a stretcher. They don't want her wheeled in a wheelchair because they don't want the jury to feel sorry for her that she's paralyzed. Remember that? I think we saw some arguments on that in the beginning when they were trying to talk about her transport.
So I'd ask that you leave your questions as they are.
All right, I'm going to take a look at it. I don't think I'm going to go just with 3, but I may combine. There are a couple of kind of just going over the same kind of area. So I think if I can condense those, that's probably what I'll do. And I'll give parties the chance to be heard again in regards to that. So it'll probably be 3 and then maybe one other one addressing that kind of issue. All right, anything else?
Would you want to consider adding the question of, do you understand that a defendant does not have an obligation to present any evidence or testify?
Just so everybody knows, what I'm also going to do is after we have the questionnaire, I'm going to bring them up, bring each juror over to the side, and then I'm going to ask, some additional questions, including the defendant not having to testify and understanding not having to present any evidence.
Yep, that's right.
Questions about police credibility, all those type of things that I would generally ask. I was just having the questionnaire because these are kind of issues that those type of questions in the questionnaire, it may be easier for people to go and kind of reflect a little bit instead of just standing up here for the first time being hit with these type questions in front of us. So I will ask, defendant does not have to testify. The defendant has no obligation to present any evidence. The police credibility question, kind of things along those lines, I'll ask over here. And then the parties can have, reasonable follow-up as well. All right.
Thank you.
Anything else?
Finally, you gestured to that side of the bench. Would the individual voir dire be?
The individual voir dire, that's just by force of habit.
Okay.
The individual voir dire, as we discussed before, will be done over here. Defendant will be here, sidebar. Okay. And then, and that's part of why we're going to take that break, to have the jury go back, fill out the questionnaire. Then we'll set it up for the individual voir dire. We'll do that over here.
Good, thank you.
Okay. All right. Now anything else?
Not for me.
All right, come on. All right, well, thank you very much. We'll see everybody on Monday, 9 o'clock. We'll begin the impanelment. As you know, it'll probably take a little while before we get the jury up here, but so if there's anything that we have to address before I go talk to the jury, we can do it then. All right? All right, counsel, thank you.
Thank you.
All right, so that is the Lindsay Clancy case. They are coming back on Monday, the 20th, for jury selection. Got to be honest with you, I don't think I can live stream this whole trial. I just don't think that I can take it emotionally, and it's going to be 6 to 8 weeks, and I don't even know if there's enough interest in it to do it every single day. Maybe recaps is the better way to go. And also, there seems to be a lot of, there's a lot of trolls on this one, like a lot. Let's recap what we did for the day, because I got to stick a fork in me at this point, because I'm done. All right. So first thing we did this morning is the Myles King evidentiary hearing scheduling. And so Myles King this morning, we saw our queen, Rosemary Scapicchio. It was on Zoom, as I recall, and it was Judge Krupp. That was in Norfolk Superior Court. That was the first thing we did this morning, and that was, I think, at 12:45 this afternoon. Rosemary Scapicchio said, yeah, we got to come back, and Lally's got to get back on the stand. And the ADA said, well, I only have 2 other people to call from Milton PD. And Scapicchio said, oh, no, I want Tully, and I want Proctor, and a couple of others too. So that is continued for Lally to go back on the stand August 27th at 9 a.m. Put it in your calendar and just label it Rosemary's Capicchio's Barbecue to be continued for an entire day of Lally on the stand August 27th. Okay. Second thing we did was we went and we watched the Sarah Grace Patrick hearing from, I think that was also today. I don't even know what day it is. That's in Carroll County, Georgia. Sarah Grace Patrick is a 15-year-old girl who's been held in solitary confinement for over a year in Georgia for the alleged murder of her mother and stepfather. Latoya Williams was her public defender. Trial was supposed to start August 3rd, and now there's a new attorney on the case. And he's like, yeah, no, because all of a sudden they've got new evidence, new guns. I got a lot of work to do. I got a lot of new evidence that was turned over. I don't only have chain of custody issues. He's like, I got evidentiary issues. I got all kinds of issues. And because of her age, I got to dot all my I's and cross all my T's. And Judge Dusty Hightower, who reminds me of Jake from 16 Candles, has said that he will take that under advisement. And I don't think that trial is going to go ahead. I think it was supposed to be August 3rd. I don't think it's going to happen, which makes me sad because Sarah Grace has been in solitary for so long because she's a child. But I think they have to at least get some time. I don't know how much time the judge is going to give the new attorney. And then from there, we went back to Norfolk County for a 2 p.m. hearing in front of Judge Doolin, our favorite judge, about Karen Reed's phones. And I was on Zoom for a while. And the reason that I have to mute myself on the Zoom is because there are other people, like the guy that popped on, with his bag of chips in the middle of the hearing, who do not mute. And when I talk to you, if the Zoom is on, my voice then comes through the Zoom and everyone knows my voice. They know it's me. And then I get in trouble, and I don't like getting in trouble. So there was a bit of silence there. I got to go back and timestamp everything. But we watched a number of other different hearings before Judge Doolin got to the Karen Reed hearing. And we saw and heard Alan Jackson in all his glory. That was amazing. If you didn't watch it, go back and watch it. And we heard Cosgrove too on the Zoom. And then we got some feed from Law Girls Not Attorneys. So shout out to them for being in court and recording. So we got to watch that almost a second time, half of it, maybe a second time. Judge Doolin was awesome. And then the final thing we watched today was the final pretrial hearing on the Lindsay Clancy murder trial, which is starting jury selection next Monday, the 20th of July in Plymouth Superior Court in front of this judge, Judge Sullivan, who I happen to like a lot. And I also really like Kevin Reddington. You remember, if you watched with me the Harry Turk trial, Dr. Harry Turk, the robotic surgeon, urologist, stood trial for the murder of his wife, Katie McLean, God rest her soul. And Kevin Reddington argued that in that moment, Harry Turk just snapped and the jury came back with the lowest charge, with the manslaughter charge. I couldn't believe it. But Kevin Reddington is an amazing attorney to watch. And so I would like your thoughts on whether you would like me to live stream that entire Lindsay Clancy trial. I just don't think I have it in me. I don't think that you guys have it in you. And so I'm just going to have to figure out the best way to cover it. Maybe watch the openings live, maybe percipient witnesses live, but I think it's going to be very dark and very, disturbing. And I just don't know that I have it in me to do it. And there's probably going to be a lot of other things to cover around that time. So, let me know what you think. I'm going to make an executive decision anyway, but I do like to hear from you. I really do. I love you guys with all my heart. I gotta go. I gotta prep, for tomorrow. So I don't know if you'll see me tomorrow or not. I don't know, but let's just get back to some of these peeps in here. Bridget says, Melanie's face when the random guy shows up on the Zoom on his couch. I know, it's funny. My face has subtitles. I was even throwing in some sign language there that I remembered from like elementary school, just the alphabet. Villanelle, thank you, says, what's the purpose of the Commonwealth taking this to trial when she's admitted to it? Well, I mean, she agreed to concede to it if they would just go to trial on the should she go to a mental hospital, should she go to prison issue. But the Commonwealth said, no, we're not doing that. So they're doing it. They're trying the whole case. The fact that her husband and father of these children stands with her speaks volumes about who she really is. So sad. I know. Thank you for tuning in from Australia. Tinfoil Hat Society says this case is so sad. I don't think I'll be watching the trial. Yeah, I think we're gonna do it in a different way. I don't think gavel to gavel is the way this is going to happen. Thank you for your 10. Kathleen says, I just got Ashley Benefield's ADA flashbacks. Thanks for being here for 17 months. Trina became a member. Welcome. Long day, says Larry. I miss Karen's, but thanks for the coverage and good luck. Thank you very much. Terry, thank you for your Venmo. I appreciate you so much. Oops. And think good thoughts. All right. I love you guys with all of my heart. I hope I got a chance to thank everybody. And if I didn't, I think I did. I think we're good. All right. Thank you very much to the moderators for sticking in there today for like almost 5 hours. This was a long one. Maybe Jennifer, thank you for your Venmo. Oh, you asked me about the Jamie Floyd Bennett, the third trial. And when I have a chance, we'll look into that. Thank you, Hope, for buying me a matcha latte. I love you with all my heart, too. All right, guys. Stay cool, stay kind, stay classy. Above all, stay safe. Don't believe everything you read on the internet. Please comment respectfully. Like the stream, share the stream. You know what to do. All the things that YouTube likes. All right. Peace out. I gotta go. I'm already late for a very important date. See, Meep just joined. Thank you for watching for tuning in from across the pond. I'm glad I caught that right before I hit the end button, and I just wanted to scroll through here one more time and make sure there's nobody else that I forgot. I either put everything up on the screen or answered your questions. So thank you again, Sassy Dust Diaries and Joey Three Sticks and Denise. I think there were a couple more that I just put up on the screen. All right. I love you guys. I'll see you real soon. Make sure you have your notifications set, all the things. Do all the things. Just do all the things. All right. You know exactly what they are. I love you guys. I'll see you soon.